months ago, the current Council of Ministers fully accepted 77 recommendations in relation to the violence against women and girls. This Assembly then accepted it as a CSP. The discrimination law provides specific protection for victims of sexual harassment, and the Employment and Discrimination Tribunal's function is to decide the appropriate remedy where a breach of a victim's rights has been proved. Members may be aware that the task force report highlighted that sexual harassment in the workplace remains a concern for local women. The task force report noted as follows: women who had attempted to make a report about sexual harassment at work also described how lack of action from those in power, the lack of record keeping, and the lack of transparent and open processes work to create a culture of why bother, and I don't know what to do about this. These women raised concerns around a lack of infrastructure and resource to tackle sexual harassment that women experienced at work. Additionally, the task force report specifically highlighted the existing compensation cap on a tribunal claims allows employers to settle claims before they reach tribunal, highlighting that this means that those that do report abuse often have their claims settled without engaging in a formal resolution process, so that the cases are not formally recorded. Acts of sexual harassment at work can have a profound effect on victims and must never be seen as tolerated. We need to have a robust compensation regime in place so that the tribunal can mark such acts in the most appropriate and just way. And we need to send a message that such behaviour is wholly unacceptable and will be met with serious consequences. Increasing the maximum amount of compensation sends a powerful message that Jersey won't tolerate the abuse of islanders, either at work or in daily life. I support the increase in the compensation limits as recommended by the Employment Forum, who are neutral to this matter. It provides a powerful deterrent against abuse in the workplace, as well as a way of demonstrating we are committed to challenging the culture in which abusers feel able to act with impunity. I would urge members to consider the message that we can send to all victims in the workplace, in particular of sexual harassment, to vote against this amendment and stay with what is recommended by the Employment Forum's recommendations. Thank you, sir.
Thank you very much. Deputy Renouf.
Thank you, sir. There's one point I wanted to pick up on. Sorry, sir, you're looking at me quizzically.
I thought you were going to pick up on your point directly with me.
No,
because you were looking at me. Deputy.
No, sir.
It's one of those unconscious miscommunications. So, Deputy Renouf, please speak.
I'm glad I picked up on the body language at least. So I do want to pick up on one point that Deputy Ferre made, because I think it shows a kind of inadvertent category error in the approach that this amendment brings to the Minister's proposition. He says in his report and in his speech that allowing the original £50,000 limit to go through would add to the rising cost of business. Presumably a £10,000 penalty accepts is a low cost for business, £30,000 is a medium cost, and £50,000 is too high. But so this is not about a rising cost for business. In fact, it's not a cost for business at all. It is a penalty for unlawful behaviour. No extra costs will arise at all for businesses as a result of the increase in the maximum award for breaking the law, because compliance with the law is already compulsory. If there are costs to ensuring that an employer does not discriminate, then those costs must already be baked in to their mode of operating. The other point I think that, other points that I think I'd just like to make in passing, amplifying one or two other points that members have already made, is that the maximum figure that the ministers proposed is already both a relatively low figure in comparison with other jurisdictions and also a compromise. The Employment Forum has come to a considered view where they all agreed that this figure was the right amount. We can assume that there were different views around the table and that this is a compromise figure. Some people would have wanted more, some people perhaps less, but this was the compromise on which they all felt they could agree. I'm very pleased to follow the Justice and Home Affairs Minister because she made an important point about the value of the penalty, the message that it sends to society, and in particular the point that these cases are often settled out before they get to the tribunal. And the incentive to settle out of court is of course related to the penalty that you might face. And so a penalty of £50,000 is a message to both sides, in any case coming before the tribunal, that there might be a good point in trying to find a way of getting this sorted without going all the way to the tribunal. And I think the bigger penalty is relevant there. It was also said that the minister's proposal means that the size of potential awards is too high. But £50,000 is not the size of the award. It is a maximum. We're talking, remember, about an island which has very large employers, some of whom are extremely large and international. And it is absolutely clear from the guidance that the minister circulated, that the Employment Tribunal apply, that the penalties will be applied flexibly. And indeed, that is the experience of the way the tribunal has operated so far. And Deputy Coles gave us an example from his own experience of that. So it is not the case that £50,000 is the award. It is the award that is the absolute maximum in circumstances where you might be dealing with a very large multinational company with multiple breaches of a law that are particularly flagrant. That would be the point at which you might reach for the maximum penalty. You wouldn't reach for it if it was a small charity that had inadvertently broken the law, and in fact, in all likelihood, those cases wouldn't even come to the tribunal. This is about ensuring that for the cases where there are the most obvious and flagrant breaches, that the penalty begins to get closer than the current figure to matching the crime, if you like. It is also said that it will put undue pressure on employers who are looking to take on new workers. They may be intimidated by the potential size of an award, but the upper limit is clearly not designed for dealing with inadvertent breaches of the law by small organisations and charities. And as I think I just said, even if for whatever reason a case reached the tribunal involving one of those organisations, the tribunal has made clear that it deals flexibly with cases before it having regard to all the relevant factors, including the size, the level of intentionality, and so on. And I think the risk, if we don't go for the higher figure here, is that that bad actors, and there will only be a very small number, but these are the ones we have to have in mind, are able to get away with a relatively small fine relative to their means for blatantly discriminatory behaviour in cases where that has been proven. And I think this then does risk undermining the resolve of others to stick to the law. If a large employer can get away with a penalty that is, in terms of its turnover, tiny, it undermines the social pressure, if you like, that feeling of, well, we've all got to play by these rules. It lessens the sense of significance attached to that offence. So, in summary, I'd say this is not about a rising cost for business. It's a penalty for unlawful behaviour. There are no penalties for alleged breaches of the law, only for actual breaches. We're trying to make our island an attractive place to work. No large employer will blink at £50,000 as being the upper limit were they to break the law. They would completely understand because they operate in multiple jurisdictions where figures are much higher. And I think that £50,000 represents a Jersey compromise to this situation, and I hope that we can reject the amendment and support the Minister in her proposals as supported by the Employment Board.
Much, Deputies. Any other member wish to speak on this amendment? If another member, Deputy Walsh.
So I just want to say a few words, I think, in particular in relation to the position of the Petty Debts Court. In the judiciary, so there is a hierarchy from the Privy Council and the Court of Appeal at the top, through the Royal Court and the Magistrates' Court, down to the tribunals at the bottom. Of course, there are judicial officers at every level who are extremely competent. But the tribunal chairs are part-time judges and obviously have less experience than those higher up the scale who are full-time judicial officers. It's important, I think, that the authority of the court or tribunal in terms of its jurisdiction should reflect the level at which the court or tribunal sits. It is wrong that a tribunal should be given an authority to award compensation which is higher than a court which is senior to it. More specifically, it is wrong that the Employment and Discrimination Tribunal should be given a jurisdiction to award compensation of £50,000 or 2 or 3 times that amount in the case of multiple infringements, compared with the Petty Debts Court, which has a maximum jurisdiction of £30,000. It is simply not appropriate. It's like giving a police constable powers which a police inspector does not have. The Minister's approach to the question of alignment with the Petty Debts Court jurisdiction is expressed at page 5 of her comments paper, where she says that alignment was rejected on the basis that equating the breach of a contractual right, claims for which the Petty Debts Court is the appropriate forum, with the actual effects and consequences of an act of discrimination would be a retrograde step. And she quotes the Employment Forum, which says, the forum considered whether to recommend a maximum cap in line with the Petty Debts Court jurisdiction. However, the forum unanimously agreed that to do so would undermine the core message that workplace discrimination is considered more serious than a breach of contract and is not acceptable in a civilized society. I don't think, sir, that that is right. Workplace discrimination can be very serious, but there is a spectrum of gravity. Sometimes an act of discrimination, such as a joke in poor taste, can be not serious at all. It all depends on the circumstances of the case. Conversely, a contractual breach, for example, a wrongful dismissal, can be extremely serious. I don't think it is correct to state that all acts of discrimination are inherently more serious than any contractual breach. So I dissented from the conclusions of the panel, the scrutiny panel, and I don't really want to speak about that. except to say that I don't think that the panel really addressed the amendment of Deputy Ferry. I will not repeat what Deputy Ferry has said, but it seems to me, in a nutshell, that the Minister's proposals are over the top. Deputy Renouf says that the maximum could relate to the actions of a multinational company and should be viewed in that light. I'm not sure that is correct. The maximum penalty that can be awarded by a tribunal is an indication of the gravity with which the legislature views the breach. And I think that inevitably, if the maximum is set at £50,000, we will find that penalties for discrimination go up very substantially. I think that the maximum penalty, which is proposed by Deputy Ferry at £30,000, sets the bar at the right level, and I would urge members to support the amendment.
Deputy Scott.
Thank you, sir. Why do people make complaints? We have heard of the stress and work involved in making a claim, of reliving unpleasant experiences, of confronting the perpetrator of poor employment practice. We also have heard the tribunal rarely awards amounts of the current limit, and that employers often settle. So why would anyone pursue a claim? I can suggest a reason. It's to publicise poor employment practice and sometimes to force employers to settle. We have heard about fears that brilliant people may not come here if claims are limited to £30,000. There already are brilliant people here in this island who only comes to a jurisdiction after looking at the amount of compensation they can receive under its discrimination laws. We have heard much about bad employers, but nothing about the people who offer jobs, in order to help others. Sometimes people get it wrong. Sometimes people overestimate the abilities of others. So to what extent should those types of employer be punished? My job as a States member is to balance competing interests. I understand why those who condone discrimination would want it capable of being punished and exposed. It already is. But one size does not fit all. Deputy Ferry's amendment offers balance and proportionality in a market where there are more jobs than people already. So I therefore will be supporting his amendment.
Right, Deputy. Does any other member wish to speak? Deputy Beasley.
Thank you, sir. I sincerely hope that members will reject this amendment for numerous reasons. I think that some arguments have been made in support of it, which I don't really think stand up to scrutiny. So Deputy Balash frequently referred to this as the Minister's proposal, but let's not forget that this arises from the Employment Forum, who were tasked to look at this area. That is a balanced panel of people representing various different interests on there, who did the work on this and arrived at a conclusion which itself is the compromise, which doesn't go as far as other jurisdictions have gone and still provides for lower limits than them. And yet we're asked to go for a compromise even further. And a compromise for what? A compromise to limit the liabilities of those who, the only ones who would be subjected to the highest compensation orders here, which are those who are guilty of the most egregious breaches of the discrimination law. Is that whose side we're on? It's certainly not the side that I'm on, because I know that the only instances that awards of that level would be offered to people who have successful claims at the discrimination tribunal are those who have suffered a serious financial loss because of it after they have faced discrimination, which is appalling, and for that level of award would have to be set at such a point to mean an award of that level was necessary. Deputy Balash also spoke about the spectrum of gravity, and of course he's right, but for this limit, we're talking about people at a very far end of a spectrum, the most egregious of cases, not for the most minor ones, not for the ones where people barely suffer any loss, because we're talking about maximum awards, not mandatory awards. And of course, the tribunal would be free, and the guidance that the Minister had printed out and handed to us before is helpful in allowing us to understand what process they would go through to determine those amounts. It'll all be commensurate based on the facts of the circumstance. What we're saying with this amendment is that if you are the victim of discrimination, an act which is against the law at work, and, for example, you suffer £40,000 worth of loss because of it, you will be told you have to lump £10,000 of that because the limit is set below what it is you have actually suffered. It's to say to a victim, you have to pay your share for being a victim rather than the perpetrator of the unlawful act paying for it. And that is ultimately what this amendment would see do and would see done at such a level that will probably leave some of the worst cases completely caught out by this. Because if you're somebody who is working for perhaps a large financial firm, a firm that is most able to pay the compensation awards, you're probably going to be on a reasonably significantly higher salary than this. And it is to say to those people, sorry, but you have to stump up your share of that loss, despite the fact that you're completely innocent in this. I think that's wrong. I think that it's right that every aspect of our society, be they businesses, charities, civil society, all of us should be aiming to uphold the best principles we can in anti-discrimination and making this a society in all walks of life where people can get on, irrespective of what their background is, irrespective of what characteristics they have, to get on in life and live with the same aspirations and potential as anyone else. And if through no fault of their own, they are set back in their lives because they've been discriminated against or subject to something unlawful because of those characteristics, then the law ought to be on their side to make up for the loss that they've suffered so that they're not set back even further in their life. And this amendment, which picks a figure which was not tested by the Employment Forum, which was not the conclusion that they arrived at, having consulted and having on that panel representatives from employers, said was the appropriate figure for Jersey. So we've had representations from other organisations who've been interested in this, and I think it was noteworthy those that contacted us earlier today to express their support for the Minister and this proposition. I haven't detected much of a mood from organisations that are genuinely scared about what prospects they may face if the limit is set as the Minister for Social Security has proposed. Maybe others have heard it, but I haven't. I haven't heard of a groundswell of opposition to what she's proposing in this, to say this really will be the final straw for us. What I have seen is lots of business leaders who I admire very much because of the work that they are doing alongside their business commitments to try to make our economy and business environment as friendly and welcoming as possible for people who from all sorts of backgrounds and with different characteristics, to say that this sends out the right message. And if they're saying that that sends out the right message, this amendment sends out the wrong message. And this will be my final word on the matter, sir. The message that it sends out is that if through no fault of your own, you are subject to unlawful practice and you are the victim, even if the loss you have suffered goes above this amount, you will have to pay for it. And that I consider to be completely unjust, sir, which is why I oppose the amendment.
Very much. Does any other member wish to speak on the amendment? If no other member wishes to, Deputy Porritt.
Thank you, sir. If you ever been discriminated against in your workplace, the detrimental impact that affects that person it can be at times immeasurable. It's not just that moment in time of the person is being discriminated. It can affect their lives, their future, their family, their confidence, their work prospects, and so on and so forth. As many members know, I have been working very hard with migrant workers, and with some of those cases, I have been supporting them in employment tribunals. It's a very hard and difficult situation to go through for anyone, never mind for those who don't have the same life experience or understanding or the support network of the island like some of us have. It's not an easy thing to do, and like Deputy Dublé has mentioned, she doesn't believe, and I know for a fact that it's not easy for somebody in a low income to put themselves through an employment tribunal to highlight the facts of their discrimination. And that is a fact. It's the hardest thing anybody can do, and a lot of the times the employment tribunal does not go in favor of that person, but the repercussions is that will affect that person for the rest of their lives, also as the families. But what I want to say right now is not about what I've just mentioned, that you all know I work with, but I also want to talk about different businesses. I think Deputy Malcolm businesses he has focused on, and the 30,000 fee deduction or compensation deduction is probably more to do with small businesses. I have a small business and I can see how that would affect. But we must not forget that there are other businesses in this island, and there are businesses who are operated by very large corporate companies. And those who work in those businesses, they have different salaries to those who work in maybe less skilled businesses. So I do believe that workplace discrimination happens in all settings, and we must not forget that corporate companies employ people who also suffer from racial, disability, sex, ageism, and also and all sorts of other discriminations. Those professionals' salaries are much higher than the round-the-mill person like ourselves, much higher. They can have salaries of £100,000. But they do also suffer discrimination in workplace. So what I'm trying to highlight is that the 30,000 compensation, it's not enough to actually make a difference for those people. And are we there to say that it's okay just to take a £30 salary when you have a mortgage of, 5, 6, 700,000? It's not okay. And I think we have to think about those employers as well. I believe that the Social Security Minister proposes the uplift of compensation amount to 50,000, which will send a very strong deterrent, not just so much to the smaller business, but to the larger companies as well. And we wanted to send a message that discrimination in terms of employment in Jersey is not acceptable. I believe that the Employment Forum is online in the same thinking process as the minister and supports the minister with that. And I think if we are to change that law, we have to change to make sure that every employee, if they win against a discrimination claim, they will feel that they have been vindicated by such, and their salaries or the compensation will actually go a long way to give them some sort of security of moving forward life. Thank you.
Very much, Deputy. Is there any other? Chief Minister.
Thank you, sir. I just wanted to say a few words in support of the proposition proposed by the Social Security Minister. And this has led to some good in-depth discussion around the Council of Ministers table. But just referring to the paper she put out earlier, so I'd just like to remind members of the important overriding objectives that this is trying to deliver. And I'm pleased that all members present in the Assembly supported the principle of what we're trying to do. And I also respect the Deputy Ferry's position in legitimately asking for what he feels is a rebalance in the payment, which I will not be supporting the amendment, but I think Deputy's aware of that. And of course, and I'm quoting from the piece of paper, the overriding objective of this is to enable the tribunal to deal with cases fairly and justly, and ensuring the parties are on an equal footing. Now, there are some moves to ensure that as well, including some deterrents in relation to avoiding vexatious and repetitive claims. And I think Deputy Balash referred to an issue in relating to cost, but I actually think that's an important a part of what we're doing. So I think the principles are sound. The debate over whether it's £30,000 or £50,000 or an annual salary, I think is important to have. But I would remind members to go back and think about especially the violence against women and girls and recommendations and what we're trying to do to eliminate as far as possible, discrimination across our community and our society. So regretfully, I can't support Deputy Ferry's amendment on this occasion. We'll be supporting the Minister. Thank you, sir.
Very much indeed, Chief Minister. Then, Deputy Wilson.
Thank you, sir. There's a quiet, enduring horror in being treated unfairly, a kind of injustice that seeps into daily life, eroding not only opportunity but dignity. To be discriminated against is not merely to face exclusion, it's to be told implicitly or explicitly that your worth is negotiable, that your identity is inconvenient, and that your presence must be justified. This kind of harm is not always loud. Often it arrives subtly, a job application that goes unanswered, a promotion withheld, a seat at the table never offered. These moments, though individually small, accumulate with devastating weight. They send a message that some are less welcome, less competent, less deserving, solely because of characteristics they did not choose and cannot change. The horror lies in the internalisation of the treatment. It creates self-doubt where confidence once stood, silence where a voice should be heard, resignation where ambition once lived. People begin to shrink from spaces that were never meant to exclude them, internalising the false narrative that they are somehow less. In a just society, fairness is not a privilege, it's a right. Discrimination, whether overt or systemic, is a betrayal of that right. It fractures communities, diminishes talent, and perpetuates cycles of harm. Most damaging of all, it erodes trust in institutions, in leaders, and in the very idea that justice is possible. To confront this horror is to confront the uncomfortable truth about how power is distributed, how bias is normalised, and how systems, if left unchecked, can perpetuate exclusion. It demands that we not only change laws, but challenge attitudes, that we listen, we believe, and we act. Justice delayed or justice obscured by complexity is justice denied. And for those who live daily under the weight of unfairness, The urgency is not theoretical, it is personal, immediate and profound. In the context of rising workplace discrimination claims, confusion over legal time limits and debate over fair compensation, as seen in Jersey's recent Employment and Discrimination Tribunal report, and the proposal put forward by Deputy Feltham, the right thing to do involves a multi-layered, principled response grounded in fairness, accessibility and systemic change. It is unjust for legitimate claims to be dismissed due to confusion over legal deadlines, especially when the system is already difficult to navigate for many. A maximum award for discrimination claims to reflect the seriousness of the harm caused should ideally be accompanied by a graduated scale. A higher cap of £50,000 affirms that discrimination is a grave matter, not just a technical violation, but a violation of human dignity. The right thing to do is not only to correct what has gone wrong, but to prevent future harm through legislative clarity, meaningful compensation, education and cultural change, as we've heard many speak on this issue previously. Fairness and inclusivity must not be abstract ideals, but active commitments reflected in our policy and our law and our practice. When someone experiences discrimination in the workplace, it isn't just about being passed over or treated unfairly. It's about being made to feel that who you are makes you less worthy. That kind of harm runs deep. It affects mental health, livelihoods, and long-term trust. And right now, Jersey is failing too many of those people. The recent report from the Employment and Discrimination Tribunal paints a troubling picture. Discrimination claims are rising. 34 were thrown out last year simply because they missed a deadline that even the tribunal admits is widely misunderstood. And that's not justice, that's just bureaucracy at its worst. Deputy Feltham's proposal proposes raising the compensation cap to £50,000. And what's clear is that the current limit doesn't reflect the real damage caused by discrimination. £10,000 isn't just inadequate, it's insulting. It suggests their experience is only worth a fraction of the harm endured. And of course, we must be mindful of employers, especially small businesses. But fairness cannot be compromised because we fear discomfort or cost. A just society doesn't just measure the price of discrimination by what employers are willing to pay. It measures it by what victims deserve to recover. What's needed is a thoughtful, balanced response to raise the compensation cap to a meaningful level, to clarify the law so people don't lose claims on a technicality, and also to educate the public and equip employers with the tools they need to do better. And most importantly, to centre the voices of those who've lived through discrimination, not just in shaping policy, but in holding power accountable. Fairness and inclusivity are not lofty goals. They are a bare minimum. Jersey can and must do better. And on the one hand lies the need for stronger protections and a more accessible path to justice for victims of discrimination, and on the other, legitimate concerns about unintended consequences, particularly for employees and workplace dynamics. Current limits such as Jersey's £10,000 ceiling are often symbolic at best and insulting at worst. Discrimination can have a lasting financial, emotional and psychological effect, none of which are adequately addressed by minimal awards. And it is for this reason, sir, that I'm supportive of the Minister's proposal to increase the cap. Thank you.
Deputy Tadier.
Thank you, sir. Sir, the demand for any kind of rights, but let's talk about human rights, anti-discrimination, often come from periods of great turbulence, division, where there is widespread discrimination, or certainly pockets of discrimination against certain groups. But the application of anti-discrimination laws, when they do and have finally come in, is hopefully applied in peacetime, so to speak. So just because laws change on one given day, it doesn't mean that attitudes automatically change there and then. There are movements demanding more rights for more people, usually by excluded groups and for excluded groups. And so when I think back to the Jersey context and my time in this assembly, When I came into the Assembly in late 2008, sir, we already had in place the Jersey human rights legislation, which mirrored EU, or rather European legislation in that regard. And of course, we know that although it's not legislation necessarily, but the UN Convention came after that big period of turbulence at the Second World War, where there was a great reflection internationally about what human rights meant and who might have those human rights. The universal human rights is a key indicator as to who that should apply to, which i.e. everybody. Later on, well, first of all, I remember one of the first questions I asked of the then Chief Minister at the time, and it was Senator Lesueur. When we didn't have any discrimination legislation, and as members might imagine, a lot of the question times focused, especially from the newer members, on when are the government going to bring in any anti-discrimination legislation. And no doubt I was one of those members who would be probably unparliamentary, so I'm not sure, let's test the mood of the chair today, who would have been considered to be banging on about a particular niche issue. So my issues might have been discrimination, human rights, and no doubt there are members currently who could be accused of banging on, sir, about their own particular hobby horses. I won't push the limits too far. I think members
might be too much.
Members know where I'm coming from, sir. And I don't think anyone should make an apology for that, because actually these issues need to be raised. And the answer that I was given, and I haven't been able to find it yet to date on Hansard, so I would look very gratefully to the GREF staff at some point to see if they can help me locate it. The kind of answer I was given was basically, well, I'm not sure if we really need any anti-discrimination law at the moment in 2008. Wouldn't it be better if everybody could just be nice to each other? That was roughly the gist of what was said by the then Chief Minister. Fast forward on about 4 years, of course, in 2013, we do see the first elements of the discrimination law coming through, and it starts off with race, not because that was necessarily the most pressing. It was an important part of the characteristics that were being protected, but it's probably seen to be maybe one of the more straightforward ones, I don't know. And that was introduced, and it gradually got rolled out, sir. The debate that we're having today really is a microcosm of that same old debate that we always have in this assembly between progress and staying the same. And I sometimes remark, looking back over 16 or so years now, that we've made remarkable progress, not just in this assembly, but as a community. The attitudes that we saw even in 2008, which doesn't sound like a long time ago, if we think about attitudes to same-sex couples, for example, same-sex couples couldn't even have a partnership then, let alone have full marriage, sir, something which I think we take for granted today quite rightly. It doesn't mean that discrimination against same-sex couples or homosexuality have changed overnight. Because invariably what happens is that government isn't the leader in these things. You have a progressive element in society, so that lobbies for greater rights, greater inclusion, greater acceptance for different groups that are being discriminated against. And we should remind ourselves that this isn't just theoretical discrimination, this is discrimination that has an actual tangible impact both on the individuals and those around them. So there are, of course, other types of discrimination that take place. The Home Affairs Minister has quite timely, in a timely way, reminded us of the importance, quite rightly, that is being given to our societal attitudes towards women and young girls. And never has that debate been more needed, I think, so. If we see what's happening in an increasingly polarised and toxic social media setting, it's really important that we do fight for those rights and that we don't get complacent, sir. And we could go through all of those characteristics which I touched on earlier during the in principle part of the debate, sir. I hope we all stand against all forms of discrimination. And I think, let's turn to this particular amendment then, sir, and ask why it's being brought and what would the consequences be if it were passed as opposed to what the Minister is putting forward. I do want to look at the politics of this. I must admit, I know where I fall on this, sir. But I find the politics needs to be looked at because we do have, as somebody who's both a backbencher with a party that's partly in government, but who also likes to think about the issues especially when they relate to human rights. So I do look to the government for some kind of leadership on this, and I see that the speakers that I'm primarily want to hear from, and I think who have already spoken, and who I would look to take my steer from, are those whose portfolios it affects the most. So we know that the Minister for Social Security has been very clear about why she wants a cap set at 50,000. She said that's already a compromise figure, that actually what we're looking at here is harm and loss, so real harm that's taken place. We're looking at real breaches that have actually been confirmed and upheld by the tribunal, not tentative ones. And her position, and I think probably mine as well, is that in an ideal world, there wouldn't be any caps. You do this on a case-by-case basis. The position being put forward by the mover of the proposition, himself both a former Social Security an assistant minister and now an assistant minister, I think, at young people and for young people, sir. I'm not suggesting he's bringing this as a minister. But it is curious that there seems to be clear divisions in the Council of Ministers, because I prefer to take my steer from the Social Security Minister, the Home Affairs Minister, whom this also clearly falls in line with, who said very strongly today that we should be rejecting this amendment, and more recently from the Chief Minister, who's responsible for setting the overall policy direction. Because this does talk about the message that we're sending out, not just to ourselves as an assembly, but to the wider public and to the wider community, about whether we take discrimination and acts of discrimination that have actual harm on people seriously, or whether we actually try to minimise that harm that is taking place. Something curious about this amendment, sir, being proposed by Deputy Ferry, is that not only does it seek to reduce the maximum amount that can be claimed per infringement from £50,000 to £30,000, so a 40% reduction, but it also has a second part. So if you like, this is a double whammy on people who might have faced discrimination and what they can actually be compensated for, because it says that rather than claiming £30,000 a year's salary, whichever is the maximum, it says the opposite. It says that it's either £30,000 maximum or a year's salary, whichever is lower. This means that, of course, on the one hand, lower earners will be discriminated against in terms of what they could claim. I think if it had been an upper limit, that it would be your salary that you could claim, or a higher amount. So a person who may only earn a relatively low amount of, say, £20,000, £25,000 a year won't even be eligible for that £30,000 of maximum compensation, even if the loss and the harm to them is quite egregious. The second point is it discriminates against higher earners, of course, because if somebody is earning £50,000, £75,000, and actually the loss and the harm that they've had relates to their yearly salary, and it might be that they find it difficult to get work initially, or they have to leave the island, all sorts of reasons that mean that they might have had a breakdown because of the way they've been treated in the workplace and can't work for a year, they can still only get £30,000 capped, even though their salary may well be twice, 3 or 4 times that amount. So even the amendment by its own logic doesn't really make any sense. So that's why I would prefer to go, and it's not about accepting what a policy forum on this particular issue has to say, but it's about accepting the fact that they have looked at this in the round. They have made recommendations not based on any political ideology, but based on the fact that this seems to be a well-balanced proposal, and that hasn't happened with the best will in the world with what's being proposed in the amendment here. I think we need to move past a potential desire that some may have come into this debate with, saying that on the one hand I'm pro-worker, anti-discrimination, or I want to send a strong message of being pro-business out there, and therefore this is going to protect businesses, because it doesn't do that. When Deputy Scott talks about this isn't a one-size-fits-all when it comes to compensation, well, this is exactly what is being proposed here. In fact, both methods, if you like, are proposing a one-size-fits-all. It's just that if the one size that you're proposing is much smaller, It's 40% smaller and it's capped, so in fact it doesn't even reach that 30,000 for many who are lower paid. What that means is that it's much more restrictive, much less flexible than what is being proposed by the Minister for Social Security, what's being supported by the Chief Minister, and what is also being supported by the Home Affairs Minister. If there is a difference of opinion from other key ministers, I think before they support or go against the minister who's in place, they should at least have the regard to put that on record, I would suggest, sir. But from what I've heard, the arguments today, I get that they've been, there's been some good speeches on both sides, but for my part, sir, I'm fully supporting the recommendation of the Employment Forum and the Social Security Minister on this one.
Very much. Colin Harbison, John.
Thank you, sir. So this morning, when I turned on my radio, I heard the report that last year we saw the highest level of cases before a tribunal. How do we solve that, sir? Well, I think we need both the carrot and, unfortunately, the stick. I will be supporting the Minister and not the amendments. Deputy Curtis spoke earlier this morning about policies and procedures. Well, sir, there's plenty of help available for organisations who don't have policies and procedures in place, or indeed for those businesses who need to refresh their policies and procedures. But policies and procedures aren't the only thing, sir. You also need to train people how to use those policies and procedures, and also raise awareness of employees about those policies and procedures. We heard somebody this morning say they didn't need training, sir. Well, I'm an old dog, sir, and I always need training. So we're never too old to learn, sir, and I think it's really important subject. So I get told off for holding the door open at sometimes, but that's the way I was brought up, sir. But I don't think it's wrong, but some people get offended by that. So we have to learn, and we've got to keep learning. So I think the amendment is well intentioned, but I don't think that it protects small businesses from going bankrupt. I cannot believe, and perhaps the Attorney General can help me here, sir, I don't believe that the tribunal would make an award that would see a business go out of business because of that award. I wonder if the Attorney General could help with that question.
Are you able to offer any advice? I'm not entirely sure it's a strictly question, but any advice, Mr. Attorney?
So that is, as a matter of generality, I think that's correct. There may be an unusual case where the level of conduct is so poor that the tribunal may think a message needs to be sent, and it doesn't really matter whether the business will survive or not. I trust that assists the Deputy.
Thank you, sir. So I think I'd ask members to reflect on Deputy Poiret's speech, sir. I thought it was very powerful, and so I'd urge members to reject this amendment and to support the proposition. Thank you, sir.
Does any other member wish to speak on this amendment? If no other member wishes, Deputy Kovac.
Thank you, sir. I also stand today in full support of the Minister's proposition based on the recommendation of the Independent Employment Forum rejecting Deputy Ferry's amendment. This amendment risks sending the wrong message, that discrimination doesn't need to be taken seriously, that the financial cost to employers matters more than the lived consequences for victims. That cannot be the message we send in 2025. The original proposal raising the maximum award for employment-related discrimination from 10,000 to 50,000 or 52 weeks pay, whichever is greater, is grounded in research, consultation, and balance. It reflects the unanimous view of the Employment Forum, an apolitical body with equal representation from employers, employees, and independents, established under law and trusted by this Assembly for over 2 decades. This is not about punishing businesses. It's about encouraging fairness, accountability, and respect in our workplaces. It's about supporting equality, protecting vulnerable groups, and making discrimination unacceptable, not just in principle, but in practice. Reducing the cap to 30,000, as proposed by Deputy Ferry, misses the point entirely. Worse still, removing the whichever is greater clause undermines the accountability of larger, wealthier businesses, those best positioned to absorb the cost of justice. It's a move backwards, one that fails to reflect the seriousness of the harm people can suffer through discrimination. The idea that businesses might stop hiring disabled people or those with differences because of fair compensation rules is not only unfounded, it's harmful. It reinforces damaging stereotypes that people with disabilities are a risk. That's not the kind of Jersey we want to build. I will be blunt. There is zero evidence that current or proposed levels of compensation have created a flood of claims. I've also looked at the numbers. Between 2020 and 2024, only 6 discrimination claims succeeded. Just 1 hit the current cap. The reality is most victims never make it to tribunal. The current 10,000 limit, picked arbitrarily over a decade ago, acts as a deterrent, not to bad employers, but to victims. It stops people coming forward, and that's unacceptable. Let's not forget that this proposal also supports victims of sexual harassment, disability, discrimination, racial injustice, and more. These are serious harms, often career-ending. A 30,000 cap won't cut it. In fact, as the Jersey Community Relations Trust has said, the 50,000 cap may still be too low. In the UK, awards are uncapped, and severe breaches come with uplifts of up to 25% for procedural failures. Jersey is behind, not ahead of the curve. Even Guernsey, which rejects Jersey's model, now offers more in serious cases. So why are we treating Jersey employers as somehow uniquely fragile? Ethical businesses already do the right thing. They have nothing to fear. It's also worth noting that Citizens Advice of Jersey and Scrutiny both back the minister's position. They emphasize that compliance with the law, not avoiding accountability, should be the goal. As Citizens Advice said, rather than worrying about legal costs, businesses should embrace this as a chance to strengthen their workplace. I couldn't agree more, as this is the best way to avoid compensation fee. That's why it's more disappointing to see that this amendment is brought from a former CEO of the Citizens Advice Bureau. Reducing the cap risks undermining public trust in consultation processes. Islanders engaged in good faith during this review. Their voices matter. If we reject the forum's findings now, why would anyone participate in future consultations? Sir, this amendment isn't just flawed, it's misguided and damaging. Supporting the original proposition is an opportunity to say clearly, we value inclusion, we support justice, we believe discrimination has no place in Jersey. This is our chance to build a stronger, fairer economy where people are protected, employers are supported to do the right thing, and no one feels silenced. Let's back the forum's finding, let's respect the process, let's stand for equality, and let's reject this amendment. Thank you.
Does any other member wish to speak on the amendment? If no other member wishes to speak on the amendment, I close the debate and call upon Deputy Farage to respond.
Thank you, sir, and thanks to all members who have contributed to the debate. On the whole, it's been quite good-natured. I'll just go through some of the comments that were raised. Early on, Deputy Coles raised the issue of per alleged offence, and I was referring to having had experience in this sphere. When an employer seeks advice on these matters, then at that stage it's an allegation. And the way it works in the real world is an employer, very often, the first time they know about these cases are when they get notification from the tribunal. And if they're sensible, they seek advice or they seek legal advice. And they go to a lawyer and they ask, what am I looking at here? What is the damage? And ultimately, of course, that advisor has to give them what the top end could be and could mean for them and could mean for the business. And that is why I framed it in those terms, because at that stage, when an individual is seeking advice, it is an alleged offence. Deputy Barbara Ward spoke about the Petty Debts Court, which sets the bar, which in my view is quite right. Deputy Catherine Curtis, I believe £30,000 is still a substantial increase. As I said in my speech, an index-linked amount would be £15,000, and I do accept it does need to rise above that sum. Deputy Doublé spoke of wage growth and inflation over 12 years. since the law was drafted, but £30,000 is still a 200% increase. Wage growth has not increased by 200% in the last 12 years. The Minister for Social Security, I just want to remind her, firstly, thanks to the Minister for the conversation that we had in the ministerial office. Although it was difficult for both of us, it's always good to have those conversations and to thrash out the ideas. But I just want to remind her that it's not an attempt to undermine the Employment Forum and their recommendation, and also to remind her that the Employment Forum recommendations have been overturned on 2 occasions in the past for different reasons. So Deputy Lahadgar mentioned about sexual harassment and settling claims before the tribunal. I still think that a rise to £30,000 will still send a powerful message and will change the culture, because sexual harassment in any workplace is abhorrent and should not be tolerated by anybody. I want to make that clear. Deputy Renner spoke about the rise in, I spoke about the rise in cost for business. Again, when a business seeks advice, they need to know what is the top line of what they're looking at in terms of cost, and they factor that in to their bottom line. My colleague and party leader, Deputy Balash, explained the judicial process very well, and he gave a very good account of using the analogy of a police officer. I think sets out the issue very well. Deputy Scott, I couldn't have put it better myself. Sometimes people get it wrong, and this amendment is about balance and proportionality. And finally, Deputy Porre, the effect on the person, I do understand the effect on the person. I have sat in rooms with people who have been affected by discrimination. I understand the effect it has on them, their family, and their colleagues and friends. So this is not blind or deaf to those problems, but what this is a sensible, reasonable amendment, and I ask members to support it, and I call for the appel, sir.
Right, the appel is called for. I invite members to return to their seats. The vote is on the amendment brought by Deputy Ferry. I ask the greffier to open the voting and members to vote. Members have had the opportunity of casting their vote. Then I ask the greffier to close the voting. The amendment has been adopted. 23 votes pour, 21 votes contre, no abstentions. Yes, the names are called for.
Those members voting pour, the Connaught St Brelard, Trinity St Peter, Grouville St Juan and St Saviour, and Deputies Labby, Luce, Ayer, Moore, Osoph, Balash, War, Miles, Scott, Rose Binet, Miller, Howe, Tom Binet, Ferry, Alex Curtis, Barbara Ward and Andrews. And those members voting contre, the Connaught St Helier, St Martin, St John and St Mary, and Deputies Southern, Tadier, Owls, Farnham, Mesick, Coles, Porre, Renouf, Catherine Curtis, Feltham, Jern, Kovac, Wilson, Stevenson, Lehegara, Dublé and the Connaught St Clement.
Very well. We now resume debate on Article 8 as now amended. Does any member wish to speak on Article 8 as amended? Those in favour of adopting Article 8 kindly show. Those against? You propose Article 9, the citation provisions, Minister?
Yes, sir.
Is Article 9 seconded? Yes, sir. Does anyone wish to speak on Article 9? Those in favour of adopting Article 9 kindly show. Those against? Article 9 is adopted in second reading. Do you move in third reading, Minister?
Yes, sir. And if I may, I would like to say a few words about the two further elements of the changes to the employment legislation, both of which are subject to amendment by ministerial order. The first relates to the remedy for breaches of contractual rights, for example, to a guaranteed bonus payment or notice or holiday pay. The current jurisdictional limit of the tribunal to compensate such breaches is £10,000 and has been at that level since 2009. The level was set to reflect the then jurisdictional limit of the Petty Debts Court. In 2018, the jurisdictional limit of the Petty Debts Court was increased to £30,000, and I propose that that limit should now also apply to awards made by the Employment Tribunal. This, as the Forum points out, will enable the vast majority of awards to be dealt with within the Tribunal's jurisdictions and avoid the need for successful claimants to incur financial costs and delay by having to go to the Petty Debts Court or the Royal Court if their award or any part of it exceeds the current £10,000 limit. Sir, the second element relates to the recommendations of the Forum in relation to claims for unfair dismissal. The Forum proposes that the scale of compensation should be extended. Currently, the scale prescribes a maximum of only 5+ years' service for an employee to receive the maximum financial award. The scale is based on the number of weeks' pay and an employee is entitled to, depending on the length of service. I agree with the Forum that two further levels should be added to reflect longer employee service. Higher compensation awards will apply to those employees who have completed more than 10 years service and more than 15 service respectively.
And so you move the adoption of the law in third reading.
Yes, I do, sir. Sorry.
Is the law seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? Those in favour, Deputy Tadier? Will you call for the appel? Does anyone wish to speak?
Yes, sir.
Deputy Tadier.
Thank you, sir. So, in the third reading, I'm interested to maybe give some thoughts about the process by which these changes happen or don't happen. I get the strong feeling that in Jersey we have a way of doing human rights that is very piecemeal. So, for example, we find ourselves in a strange situation where we have a children's rights commissioner in Jersey. We know that that came about in reaction to a specific course of events, which was the historic abuse inquiry and the recommendations that came from that. Yet there aren't just children that live in our community. There are adults, there are lots of people who face discrimination. And one of the things that I have suggested that we should have, sir, to make sure that when we pass laws like this and consider amendments, so that we don't consider things based on emotion or gut feeling, putting the proverbial finger in the air, see which way the wind is blowing, sir, is that we actually have bodies that are dedicated to this kind of thing. And whilst we do have forums, of course, in this case the Employment Forum, we lack that wider consideration and societal debate, therefore, around issues such as equality and human rights. And where does that come from? Well, it is supported in other places, other countries, by well-established equality and human rights commissions that exist. And it is both a body which is able to listen to the public mood and make recommendations on the basis to those in power and to speak truth to those in power, something which we don't have in Jersey. And it has to be said, I think, that often we as politicians, of course, politicians who can come and go, we end up listening to the loudest voices. We end up listening to the ones who vote at election times, the ones who know how to get in contact with us, the ones who know our phone numbers and our email addresses. And we don't really have necessarily much contact or knowledge of what is wanted by those who maybe do not have that same level of empowerment that others may have. And so when it comes to these kind of laws that we pass, which include about levels of of compensation, sir, for loss and harm, it is with those considerations in mind rather than maybe the objective considerations that might arise from a more wider, profound consideration from a body whose specific purpose is to deal with these questions, sir. I'm also not blind or deaf to the fact that we often don't listen to certain voices of people who settle in the island, and they say, of course, it's a beautiful place to live and even drive, sir, on the way back here from lunch. So I know I had to stop no more than 3 or 4 times behind a car. I was on my scooter who was letting people out from roads where they didn't need to be let out because there was nobody behind us. And when the car stopped, we had to stop for about maybe 10 seconds because the traffic on the other side was still coming. So nobody was any better off. Everybody was worse off, but the intention was at least clear that they felt that they wanted to do something right, sir. And the point I would make in that illustration is that good intentions are not always sufficient. Things have to often be done properly. And it's really important that we listen to people saying, why is it that things are done like this in Jersey? And we can't simply always say, that's just the way we do things in Jersey. It has to be light touch. Sometimes there is ultimately a need, if we want to be a well-respected jurisdiction, that we do things properly. So what we've seen today, I think, is in the third reading, sir, we are passing something which has been amended, which we have to do now, I think many of us half-heartedly, because it wasn't what was set out to be the original intention. It is something, unfortunately, which the government, I think, has been divided on. There's been, of course, a good indication from this Chief Minister and the key mover of the proposition, but she hasn't been supported more widely by her ministerial colleagues, many of whom have not even spoken, I don't think, once in this debate to justify the way that they have voted, but they've simply gone on being a government within a government. And I think it will be interesting to see actually what the message is that this government would be wanting to send out on the back of that in terms of its commitment to human rights, its commitment to anti-discrimination principles, when in fact what we're doing here I think is very half-hearted, very lukewarm, and something which I think is going to be very difficult for some of us to vote for.
Does any other member wish to speak in third reading? Chief Minister.
Thank you, sir. Just following on from the previous speaker, I wanted to start by thanking the Social Security Minister, indeed, all of the ministers. I think there's no shame whatsoever in a government of has been referred to as a truly sort of national government representing a broad church of political views across the interests of our island, and there is no shame, sir, in sometimes the fact that we do not always agree. Different viewpoints contribute to a more comprehensive understanding of the issue, sir, and I can say we have had comprehensive and productive discussions, sometimes challenging around the Council of Ministers table on many issues, not least this one, and I want to thank all members for conducting a healthy, sir, and a respectful debate, sir. And of course, constructive disagreement fosters debate, which is essential to our democratic process. Sir, disagreements act as a check on power when politicians challenge each other's ideals. It prevents any single ideology from dominating the agenda. So yes, we recognise there's been a disagreement. I know it's been frustrating for some, sir, but again, I think it's useful. It certainly meant we've had an in-depth discussion. And I know the outcome is not something that the Minister, myself, and some other ministerial colleagues wanted, sir. But the approval of these regulations now, in their final reading, mark a significant and welcome step forward. And I want to recognise that, the work the Minister's done, and thank the Council of Ministers of the Assembly, sir, for a constructive debate. Thank you.
Does any other member wish to speak in third reading? No other member wishes to speak in third reading? I close the debate and call upon the Minister to respond.
Thank you, sir, and I thank the Chief Minister for his support. Just to refer to Deputy Tadier, he will of course know that we have a shared manifesto commitment towards the establishment of a Human Rights Commission. So we do have a shared commitment to that. I do want to say I am, of course, disappointed that the Assembly voted and accepted the amendment and didn't support the recommendations of the Employment Forum. But I do wish to reaffirm my commitment to beating all forms of discrimination on this island. No matter where we've got to today, I think the debate has been a useful one, not least because it has given the general public a good opportunity to see where members stand on this particular position. But we are taking a step forward with these regulations, and I encourage all members to vote in favour of them. Thank you, sir.
You call for the appel there?
Yes, sir.
The appel is called for. I invite members to return to their seats. The vote is on adoption of P78 as amended in third reading. I ask Greffier to open the voting and members to vote. Members have had the opportunity of casting their vote. Then I ask the Greffier to close the voting. The law has been adopted in third reading, 42 votes for, no votes contra, no abstentions. Well, the next item of public business is evidence-based energy strategy lodged by Deputy Jeune. The main responder is the Minister for the Environment. There are two amendments, one lodged by Deputy Ozef and one by the Minister for the Environment. Deputy Jeune, before we start, are you minded to accept either or both of those amendments?
I'm minded to accept the Minister's amendments, but not Deputy Ozef's.
Very well. In which case, do members agree that we can take this proposition as read with the Minister's amendment? Very well. Ask the Greffier to read the proposition.
The States are asked to decide whether they are of opinion, A, to request the Council of Ministers to develop and before the 31st of December 2026 start implementing an evidence-based energy strategy that sets out Jersey's long-term energy requirements and balances the need for affordability, safety, security, a market that delivers competitive outcomes and carbon neutrality of the energy sector in Jersey, and B, to request the Council of Ministers to bring forward any necessary legislative changes subsequent to the implementation of the energy strategy for approval by the Assembly before the 31st of December 2027.
Deputy.
Thank you, sir. My proposition is a simple one. I'm asking that an evidence-based energy strategy be developed by the end of 2026 and that any necessary legislative changes or policy development follow by the end of 2027. You may ask why this is needed, given existing commitments agreed by the Assembly through the Bridging Island Plan, which committed to exploring Jersey's long-term energy needs, including infrastructure, economic requirements, regulation and land use to inform the next island plan, and the Carbon Neutral Roadmap, which outlines Strategic Policy 2, Island Energy Market, which called for an energy strategy with clear and accountable political leadership to be developed by 2024. Both these commitments were agreed by the previous States Assembly, albeit as part of much larger documents that contain a lot of strategic requirements, direction and plans. Many of us were not part of those discussions and decisions and may not have noticed these details. What is a concern is that we have actually missed the key deadlines set in those documents to deliver such a strategy and review of Jersey's energy needs. So this is the crux of my proposition. It isn't duplicating efforts, it is re-establishing accountability and giving this current Assembly the chance to reaffirm political will. I asked questions of the new Council of Ministers when they were appointed about energy leadership and direction. There has been no clear prioritised commitment to finalising an energy strategy. The Environment, Housing and Infrastructure Scrutiny Panel had to amend this Council of Ministers' Common Strategic Policy to ensure that the delivery of the Carbon Neutral Roadmap was part of their priorities, the energy strategy being a key deliverable within it. If we had not done this, we can see with hindsight and with continued emphasis coming from the Council of Ministers themselves that anything not contained within the Common Strategic Policy has been deprioritised and resources reduced substantially. So without the scrutiny panel's intervention, focus on energy would have been completely deprioritised under this Council of Ministers. Even in the Cabinet Office's business plan for 2025, when it comes to energy policy, the focus is on offshore wind and the CNAGE recommendations. There was no mention of focusing resources on developing an overall energy strategy for this year. And I'm sceptical that solely focusing on the SNAGE recommendations during 2025 is enough to build a comprehensive evidence across the supply chain or to consult stakeholders to ensure there is solid ground to deliver an evidence-based strategy by 2026. In the Bridging Island Plan policy area of the Cabinet Office's business plan, there is no mention in 2025 of work to be done on strategic proposal 2 on understanding the long-term requirements of Jersey's energy market. Also, in a letter to the Environment, Housing and Infrastructure Scrutiny Panel in January this year, progress of this particular strategic proposal under the Bridging Island Plan was marked as RAG status orange, i.e. delayed and not on track, with the current status being focused on offshore wind, and for work to be further developed addressing markets and pricing under energy policy work. Great. But then there is no mention in the energy policy work under the Cabinet Office business plan to work on this. So therefore, where is it? It's hard to keep track with all these different documents and all these different decisions that should be made, and then actually when it comes to the plans, they're not there. And we even heard from the Minister for Infrastructure that though he told the Assembly in March 2024 that he was undertaking a review of the Jersey Gas Company law around the powers to introduce price regulation, this morning he told the Assembly this work never happened without any real explanation as to why it was deprioritised over a year ago. And though I welcome the Minister for the Environment's support for this proposition, I'm disappointed that deadlines have continued to be pushed, including even by the amendment from the Minister. And a piecemeal approach seems to still be at play, where we're told one thing is happening, and a few months later, or in fact over a year later, we're told other priorities have taken over. Therefore, my proposition aims to provide this current Assembly the opportunity to give a firm political steer that developing and delivering an energy strategy is critical and must be prioritised now. Without a clear and current mandate with specific public deadlines that send a clear signal of intent, I'm concerned that we risk continuing inaction. This lack of prioritisation, inaction and missed deadlines has consequences. The 2024 CNAG report on critical infrastructure resilience, focusing on energy, found that government arrangements to assure the resilience of energy supply in Jersey are weak. Arrangement for ensuring the monitoring, reporting and scrutinising of resilience information by operators and owners of critical infrastructure of energy is not established. Overall, there's a lack of coherent, joined-up approach across government with unclear roles and responsibilities. And while the Minister of the Environment says in his comments paper that he views his role as a convener in energy policy, we must ask, is that enough to drive the leadership and coordination the challenge in this area requires? Any current legislative powers are scattered around different ministers. The CNAG also recommends that in line with the development of a new resilience law, current laws are updated that govern energy provision so that they are aligned, fit for purpose and drive high standards of resilience. But can this effectively be done without understanding what Jersey wants to achieve from its energy system? The Jersey Competition Regulatory Authority's final report on the electricity market, published this year in January, found that while current outcomes such as price stability, service quality and efficiency compare favourably with other jurisdictions, there are still significant structural challenges that remain. With Jersey Electricity operating as a vertically integrated monopoly, competition with the market is limited. The report recommended clearer tariff information for consumers, improved support for self-generation, and regular performance reviews conducted by JCRA. Crucially, it called on government to refine its energy policy to create a more resilient and competitive market with a clearer pathway to carbon neutrality, providing certainty needed for both consumers, suppliers, and future investors. i.e., Their recommendation was also that important for an energy strategy. So is an energy strategy necessary? I believe it is. Jersey imports almost all of its energy, with only 3% generated locally. This heavy reliance on external suppliers makes us vulnerable to supply chain disruptions, price volatility, and regulatory decisions beyond our control. 57% of our energy still comes from petroleum products. If we're serious about reducing carbon emissions and meeting our commitments under the carbon neutral roadmap, we need a strategy that accelerates our transition to cleaner energy. There are gaps in legislation and oversight, leaving consumers exposed. The Consumer Council and the JCRA have highlighted the lack of regulation in these key areas, putting islanders at risk of unfair pricing, limited transparency, and service unreliability. There is tension between expected growth in demand for electricity driven by the carbon neutral roadmap and concerns about energy security, capacity, and supply sufficiency for the island. Within this, we face a contradictory challenge. How do we encourage islanders to reduce their overall energy consumption, improve efficiency, and shift behaviours while planning for rising demand from sectors like transport and heating? And this creates a difficult balancing act, ensuring adequate supply, incentivising cleaner energy use, and promoting conservation, all without placing undue cost burdens on consumers or compromising resilience. Energy price rises have contributed to the cost of living crisis over recent years. The RPI fuel component rose sharply by 22.7% in 2022, dipped slightly by 2.2% in 2023, but has risen again by 7.8% in 2024. These averages, however, mask large variations between different fuel types and suppliers, with some households and businesses hit harder depending on their energy source. The latest figures will be published later this week, but Island Energy and Jersey Electricity both increased their prices for 2025 by 7.5%. We're also entering a period of rapid technological change. New energy technologies, emerging transition fuels, and innovations in storage and smart grid systems are transforming how energy can be generated, distributed, and consumed. These developments present a real opportunity to democratise our energy system, giving households, groups of households and businesses greater control and even the potential to produce and store their own energy. But to unlock these benefits, we must ensure that the right strategic frameworks and regulatory structures are in place. This is especially important as we develop future island plans, so that new infrastructure, housing developments, and transport systems align with a vision for an energy system that's safe, affordable, secure, fair, and decarbonised, while balancing concerns from islanders around food security, natural environmental impacts, and collective infrastructure disinvestment. Without a guiding strategy, we risk missing these opportunities or creating a system that benefits the few rather than the many. Transitioning to a more resilient and sustainable energy system also requires skilled workforce. Therefore, we must invest in green skills. From renewable energy to energy efficiency and smart technologies, the shift will require a workforce trained to meet new demands. Developing these skills locally ensure islanders can access new job opportunities and help build a resilient, self-sufficient energy sector. Though this has been started under the carbon neutral roadmap, it is only small steps and seem to be, at the moment, as an add-on. Therefore, my hope is that an overall strategy would align completely with workforce planning, education, and economic development to make this transition a reality. This proposition is not about fast-tracking regulation or intervention. I've deliberately avoided being prescriptive in the proposition, even if I've touched on some of the elements the strategy needs to tackle within this speech. Instead, this proposition calls for an evidence-based approach, builds around the pillars of affordability, safety, security, competitiveness, and decarbonisation, allows for targeted intervention where needed and market-led solutions where appropriate, and includes a reasonable timeframe to consult, draft, and refine a strategy. Delay will only increase risk and worsen our strategic position, a timeframe that we have already been delayed on. It's about creating a foundation for this Assembly to steer the Council of Ministers and ensure the next government is equipped to finalise and implement a clear energy plan. Our goal for Jersey should be to have a resilient, affordable, sustainable, and safe energy system that powers our homes and businesses reliably. This is not just about energy, it's about protecting our economy, securing our environment, safeguarding the well-being of all islanders, and promoting innovation and competition. And while decarbonisation is a key part of this, the strategy is about energy in all forms. Islanders want their energy in whatever form to be safe, affordable and reliable. Let's move beyond fragmented short-term solutions or deadlines that keep being pushed back. A well-defined energy strategy will provide clarity for consumers, direction for investors and stability for our economy, and it is needed now. Thank you.
So you move the proposition?
Yes, sir.
Proposition seconded. There's an amendment lodged by Deputy Joseph, and I ask the greffier to read the amendment.
Page 2, paragraph A. After paragraph A, insert a new paragraph B as follows and redesignate the subsequent paragraph accordingly. B. To request the Council of Ministers to include within the development of the energy strategy a comprehensive review of Jersey's fuel storage and distribution infrastructure, ensuring it is aligned with the objectives of affordability, energy security, market competition, and the island's transition to net zero. Such review to 1. Assess whether the existing lease arrangements and operational structure of Jersey's primary fuel storage facility support a competitive and non-discriminatory market, ensuring that all fuel suppliers have fair access at reasonable commercial terms. 2. Ensure that any renewal or future lease arrangements for fuel storage facilities, including but not limited to the La Collette fuel farm, are subject to an open and transparent competitive tendering process. 3. Examine opportunities for optimising fuel storage capacity in light of projected reductions in fossil fuel consumption, ensuring right-sized infrastructure that meets the island's resilience needs without excessive cost burdens on consumers. 4. Explore whether alternative models for fuel storage management, including the States of Jersey either directly or delegated to an appropriate majority or 100% state-owned entity, potential public-private partnerships or other non-states diversified infrastructure, could enhance both security of supply and consumer pricing. And 5. Ensure that the forthcoming energy strategy explicitly considers all options for the long-term management of fuel storage in Jersey, including a review of alternative models that separate infrastructure management from fuel supply distribution, in line with the government's commitment to energy security and resilience.
Deputy.
Thank you, sir. And I should first of all start with the appearance of a conflict of interest in my declarations of interest. I inherited a garage from my late mother in 2002, and there is a tenant, but my arrangements are such, sir, that I don't have any contact. They're all dealt with by third parties, so I don't influence anything, and I haven't been asked to do this speech or deal with anybody. So, and I think that members would understand that I have a long...
Yes, I don't think there is a difficulty there. Please carry on.
But there's also the perception of conflict of interest, and I wish to make it clear that in my remarks, I make that. So I rise with a somewhat heavy heart, having received the comments on that quite a mouthful of an amendment read so eloquently by the greffier. I wrote it, sir, by myself, based upon the experience I've had as a minister serving the island, and with a strong view about the importance of competitive markets and the ever-increasing over years cost of living problem that islanders have. Sir, I have etched on my political grave, now resuscitated, much about the fuel farm. There was a member that remembers when she was a journalist, that she first met me in 2000, and I had a spreadsheet showing the cost of fuel in Jersey. There was a Senator Norman that brought a proposition, sir, to abolish fuel duties. And as a young, fresh member of the Finance and Economics Committee, I was delegated the responsibility of ensuring that the F&E committee of the day didn't lose those revenues. So I'd just done a 12-month fraud investigation in a petroleum business. So I knew something about it, and duty fuels for others. And I'd worked out, basically, that despite the benevolence of states members, many times heard through budgets of having low duty prices, in fact, islanders were paying 15 to 20p more per litre than they ought to, even given Jersey's size. But the data had never been looked at. I advanced those arguments as a member of the Finance and Economics Committee, and so we are here today, sir, in 2025, and it feels like Groundhog Day. But I'm going to be true to my original beliefs, my unswerving attention to competition issues and acting in the public interest, not in the short term for popularity reasons, but getting long-term value in an important area of islanders and businesses' expenses. We all know that the cost of living in Jersey is rising, and one of those areas, as the mover of the propositions rightly said, is the concern of many individuals on the cost of their energy. And this amendment deals with the fossil fuel element of it. We have seen over now 3 terms that the fuel farm, which is the gateway into the island's energy fuel source. So if you hold the keys for the fuel farm, you hold the ability for being able to influence, should I say. I've got parliamentary privilege. You can influence, you can, if you want, and you used to be able to set the price because there is no anti-competitive behaviours. We have a competition law now, and many members like me will share some frustration in the lack of progress on, notwithstanding not having a competition law, the fact that inflation is rising. And there is a problem in the fuel market, which is why I bring this amendment. And it's not in any sense, as I made very clear, this is us against the risk of higher prices than they should be. It's us as a States Assembly acting on the public interest, and I don't regard it as the them and us in terms of my observations to the Council of Ministers. So members will remember that I have asked kindly the Chief Minister whether or not his council were considering issuing directions under the existing clause of the lease that was issued in 2016. And he kindly responded that notwithstanding the council ministers not having used the triggers that were there to protect the public interest, that he'd obtained advice from information from Rubis, the current operator, who would be entitled to an automatic renewal of the lease. And I basically benefited from that and was reassured from that. And I was somewhat disappointed, therefore, to receive, without any consultation, the comments, which I doubt, I know that this morning many members didn't even know they existed. Nobody's actually, I don't think members haven't read, might likely, and I'm not going to go through them, the comments that were issued on my amendment, which was made some time ago. And I could have done this as a standalone proposition, but I did so because of the Chief Minister's statement that it was until the 30th of April that the Council of Ministers could had that extension for not having done the lease clauses before. So it is so important that there is competition, that there is due process and tendering of anything valuable. Anything that you can print money with because you just can, needs to be properly done. As we've seen in the difficult issues to do with our sea contracts in relation to Condor versus DFCS. I went on DFCS at the weekend and was very pleased to speak with a lot of the staff. I've got great hopes for that. But sometimes it needs courage to take on vested interests. And vested interests, if they can, they will. Adam Smith had something about that, said something about that many years ago. People will fix prices if they can. And who makes them can? Well, we can. We, the States of Jersey, by directing ministers to do certain things. And my amendment was trying to get, effectively, the balance of power into the public so that decisions are made in the public interest. And not just about the issues that I was referring to earlier, the price issues, but also the important environmental issues that Deputy Jeune is at the heart of probably many of the issues that she brought the underlying proposition. Today we need to be not short-term, we need to be long-sighted. We need to be making decisions, the right decisions today, which we're going to benefit and avoid disbenefit, and particularly rising costs in the future. We need right-side storage facilities, which respects, upholds ambitions for net zero, avoiding the relics of fuel fossil pasts. We need to explore bold models of how we deal with the effects of climate change, and we see the reduction of different of traditional 100% fossil fuels. We need innovation. The petroleum industry worldwide, sir, has innovated somewhat, and everywhere else in the world, you fill up your petrol car with a product. It says it's on the fuel distributor, sir. It says E10. That means that 10% of that fuel is biofuel. 10%. And everywhere in the developed world, from North America to South America, to Asia Pacific, the whole of the European Union, the United Kingdom, has had an ethanol requirement for the sale of petrol, except Jersey, sir. Well, I say except Jersey. There is one retailer that does do it because they thought it was legal. They thought that was a legal thing. You couldn't believe the fact that we didn't mandate E10. Now, why do members suddenly take an interest in E10? Well, E10, if you required E10 to be put in cars, and I know many members have got electric cars, and if they're driving a diesel car, it's called B7, that's 7% of ethanol in diesel, then at least 7% is going to be biofuels, but not in Jersey, sir. In fact, what we've allowed is we've allowed the incumbent operator to claim on advertising that they're selling proper fuel. And I say to members, are they comfortable hearing today that the cars that they've purchased in the last 10 to 15 years is being fed by fuel that is the wrong fuel that is tested for the performance results? Cars are built to have E5 and E10 and B7, but no. We need a review, I was told, I heard on the radio when I was listening to the Net Zero review. We haven't mandated it. And it doesn't apparently matter. But these small things, sir, would matter to our carbon emissions. And if we mandated E10 and B7, just like the rest of the world do, including islands. But no, we needed a review where E10 would work on our roads, sir, I was told. That's what I heard in this place, and I thought that was bonkers. So history, like a stern tutor, reminds us of missteps of the past. In 2014, there was a notice period to tender the fuel farm that was missed, and it chained the states of Jersey, the public of Jersey, to a requirement of a lease for 10 years, and risked, so the Bailiwick Express reminded me, of a £10 million lawsuit because the states had not exercised the right to tender it at that time on the previous terms. Today, so we titter on a similar precipice. Trigger clauses meant to protect the public interest lapsed in July 2024. Chief Minister said he'd got an extension of that. But what effectively that means is we've lost the opportunity and now we have to haggle with an incumbent operator from a weakened position that never should have been the case. And I ask members, sir, do they want to see this folly, this expensive folly, which hurts every business, every household that buys fuel? Do we want to repeat this folly again? Because there's no doubt that we did last time. And it was said that the operator needed millions of pounds worth of investment in the fuel farm. Quite right. We need a safe, fire-safe fuel farm that's not going to be exposing ourselves to risk. And they're set out in Buncefield regulations. Fire officers will report that despite their requests of the fuel farm operator to comply with necessary safety firefighting equipment, they didn't do so. So they left it, of course, until the end and said, we're only going to make this investment if you do it now. But they should have done it last time. Now, I don't know the facts of what the minister's talking about with millions of pounds worth of investment, but I've heard it before. And I'm sceptical. And it's right to be sceptical, because once bitten, twice shy. The objective to tender the fuel farm facility is the reality that the lease says that we need to buy the equipment. That is a costly burden. It's a costly hurdle. And that could stifle competition because effectively you've got a barrier to entry. It's not just legalese. It's actually what I'm talking about is a tax. Don't call it a tax, but call it the fuel monopoly tax that's cost islanders hundreds of pounds every year in their rising heating oil bills and their petrol prices that are higher than they otherwise should be. We don't have VAT at 20% in Jersey. We used to have low fuel duties. Why is our fuel? I filled up my car in the UK, and the fuel prices in the UK were lower than here. Really? You've got 5% GST. You've got 20%. And when you look at it, there's a problem. But people are comparing apples and apples, but people don't mind maybe because they don't use vehicles to such an extent in the UK. But we have a responsibility to do the right thing and make sure that consumers have choice and that they're delivered with an appropriately priced product. Many people haven't got time, sir. They're too busy worrying about their wage packets and how much money they've got to necessarily go to the right filling station. So they kind of trust that the decisions are correct. And are they? Well, history shows that they haven't been. And it is extraordinary that we've actually got some garages in Jersey that actually on the fuel pump says it's E10 going in their cars. Well, of course it's E10 everywhere else, but they can't find a fuel filling nozzle which says E10. So there's consumer misrepresentation. The reason why the operator claims not to sell E10 because it's going to cost them some money. Well, everywhere else in the world does it. Why can't we do it? And I don't accept, and I don't think any person, any individual with the basis of the simple information would accept the arguments that Jersey can't do it. It's simply not sustainable. And it's not good for the environment. And we've been doing this for years. And it's the first time I'm addressing the Assembly on this issue. An alternative operator did set up in Jersey. And that alternative operator was a really good thing. They didn't use the fuel farm and still don't. And it's quite extraordinary that they use containers to bring in their fuel, which must be far more expensive than bringing in a barge of fuel and putting it in a pipe and storing it in the fuel farm. But they say that, and they're on public record, they say that the cost of investing hundreds of thousands of pounds designed to deliver effectively competition in Jersey, which was closed previously, even the cost of all those containers was less than the throughput price which the monopoly fuel farm operator, which is supposed to be fair, but it blatantly isn't. And I have no evidence today, having now asked some of the fuel operators whether they're satisfied with the operating cost per litre, and that they're not. That competition, sir, proves, and many islanders have, as a result, all garages and fuel fell by a significant amount of money, which was great. So the threat of competition, the actual arrival of competition, means consumers get better deals. And they get better deals from a price, but also from those issues such as they get actually, islanders might actually want to have biofuels if they can't afford an electric car, etc. There is a undoubted fact, sir, that the fuel farm is a natural monopoly. It was permitted to become an actual company-owned monopoly by a decision of the JCRA to allow, formerly the fuel farm was owned by Shell Transport and Trading in Esso, and they then sold. I did say when I was the President of Environment Public Services, as soon as Shell got a new lease, they'd sell it. Well, that's exactly what they did, which is why Rubis bought it. We don't know by how much, but they've obviously paid a lot of money because the value of the lease is the value of the right to supply fuel in Jersey is the lease. So if you've got the lease, you've got something worth money. As soon as we gave them the lease, they sold it. And therefore now Rubis has probably paid a lot of money for that and wants a return on it. But two wrongs don't make a right, like Condor. Net zero. We're told by the Council of Ministers they're going to issue a new 15-year lease. Is that compliant with with a future structure of biofuels, innovative fuels like hydrogen, more electric? I don't think so. I think we want to be quicker than that, according to those people who are wanting to do to get net zero. I certainly would like to, and we need to make it possible. Resilience is important. Supply disruptions or storm would cripple the island without robust and competitively managed fuel farm. But locking ourselves into a 15-year deal, as we're told the Council of Ministers is now going to do, tethers us into a fading era, not a vibrant future. So I'm not going to speak for much longer on this because I don't think that this matter, which is a matter of huge public importance, which is why I have raised it consistently and persistently, and I do what in my private life, I do the same in my public life, is I support issues of competition, because competition drives down the cost of living, and that's not the price, it's the quality of those goods. And I have no doubt that this Assembly over decades has made decisions which have not put the public interest in all its respects, safety, environmental and price, at the heart of its decision making. It is very difficult to comment on a comments paper which has no real detail I was very grateful for the Minister for Infrastructure, who I hold no criticism to at all. I know he's got a difficult job. He's got the latest poison chalice of the fuel farm problem, and I respectfully want to be with him and to assist him. And those of us who have been in the States and have known that there's been the missteps taken that I spoke of will know that mistakes have been made which have cost us money. And my concern is just simply now accepting a 15-year new lease because the operator wants it, is going to simply not do anything for net zero, not do anything for the environment. And there's one more thing, sir. The fuel farm creates, together with another hazardous product, a blast zone at La Collette, which means La Collette, the whole of it, cannot be used for public access to any great extent. In other words, there can be no great numbers of public going down to La Collette. I know that the Minister's excellent recycling centre is very well used. Hundreds of islanders use it. But that land is effectively cast in aspect because of the blast zone. The blast zone exists not because of all the fuels that are stored in the fuel farm. If members can imagine putting a match next to a bucket of diesel and petrol, I think they'll know that it doesn't ignite if you put a match next to next to diesel, but it does with petrol. So the actual hazardous material is petroleum. And if without that, because avgas is not stored at the fuel farm anymore, it's stored up at the airport, it would not have that blast zone. I didn't know that, but somebody like me will investigate why, and I found it out, and it's true. There's an issue of gas, but we've dealt with that earlier. Apparently they're going to get biogas, so that's fine. But let's deal with one thing at a time. If there was a possibility of renegotiating a fuel farm that respected resilience and gave the minimum storage requirements, it kept as much heating oil and other things that businesses and consumers want that can't transition yet to electrical, hydrogen or ground source heat pumps, then you would lift that entire prohibition of La Collette too. And I ask members to think about the importance of that. What a fantastic opportunity to reuse that land, have bad neighbours taken out of St Saviour. And looking at the Constable, I can think of a number of bad neighbour properties in St Saviour. There's lots of possibilities. Land is scarce, sir. We've got lots of it and we're not using it wisely down at La Collette. And we can, if we think. Now, sir, I'm not going to get a fair hearing in this debate because members have not had the opportunity. This is far too detailed, really. I latched on to Deputy Jean's proposition because of the deadline. It was originally, Deputy kindly indicated that she was doing it, so I put an amendment to her amendment, she moved the debate forward, but I've then kind of waited. I know I can do a standalone proposition. I've waited until the council ministers comment. I thought they were going to do something, but now I'm in total despair. But there may be despair because ministers have relied upon information that is not entirely complete. They're busy. I'm not criticising, but I know that there is a lot of questions that need to be answered, and they're not going to be answered on the floor of this assembly this afternoon. And so I think it is best, having made those opening remarks, hopefully stimulated some members' interest to know that this is a serious issue with serious consequences and serious opportunities to do things better. Better for the island, better for land use, better for the environment, better for prices, better across the board than simply making the same decision again and rolling over a lease for another 15, not 10 this time, 15 years. I give notice, sir, that I would like to withdraw my amendment. I'm going to have discussions, helpful discussions with the Infrastructure Minister, who I've only spoken to at lunchtime because I asked him to. I was going to be asked to attend the Council of Ministers to discuss my amendment, but I didn't get that opportunity. So that's why I've made my amendment. I've received the comment, members know about it, and I think it's best that we don't spend valuable state's time on debating an important amendment, but without the full information, because I haven't got it based upon the Minister's comments only issued on Thursday. There's been no working day since then. It's been 2 bank holidays. I thought it was rather strange that they were issued on Thursday afternoon, but I'm not a conspiracy theorist. I'm sure it was done. I was told that it was going to happen, so I think I should withdraw my amendment, sir, and I will have discussions. And the members of the Assembly can be rest assured that I'm not wasting their time that I will be back if I can't see a decision made by the Council of Ministers upon the advice of their officers, which is manifestly and provenly in the public interest, without favouring or criticising any third party, any operator. Businesses are there, I'm a free marketeer, they need to work within boundaries that are acceptable and fair. And what we've had in the past is not fair, sir. And what the Council of Ministers is saying at the moment is that they're going to continue what I consider to be an unfairness. And there is proof of that with JCRA decisions being quashed in the Royal Court, etc., etc. So regulators don't always get it right. And I think I should leave it there, sir. I thank members for their kind attention in listening and hopefully having read both my amendment, which I mean every word of it, but now is not the right time. The mover of the proposition doesn't want to accept it, so I'm not really going to get it accepted. So I'm not going to waste members' time. I'll withdraw it and I'll come back with those same remarks. But I've now said what I've got to say about the generality of the issues, so I hope I'll be more succinct when I bring forward a standalone proposition, if it is necessary and if the Council of Ministers press ahead and under standing orders, any lease can be called in. And I give notice that that would happen because it would be the dereliction of duty not to do so. Thank you, sir.
Deputy Joseph, you're entitled to withdraw your proposition because the debate is not yet opened. Therefore, that's treated as withdrawn. And we now move to continue for any debate on the main proposition. And does any member wish to speak on the proposition? Deputy Luce.
Thank you, sir, and I'm pleased to rise at this time to respond to the chair of my scrutiny panel, and members will have read my comments that I published, provided a bit more detail, and to say how I'm working on an energy strategy. Members will also be pleased to know that I don't intend to repeat everything in this speech. But I just want to say that the chairman of scrutiny, Deputy Jeune, and I are pretty much aligned on this matter. I understand the importance of the strategy. I've already built this into my work programme this year, although, of course, as the Deputy's already said, not quite as quickly as she would like, and she's entitled to have that view, not quite as quickly as I would like, but there's other things that need to be done. So energy is a critical resource for our community and economy, and we're fortunate to have a variety of energy providers and a very reliable supply chain in that provision. However, the market isn't without its challenges, and we have seen volatility in energy prices in the UK and elsewhere, although thankfully we have been sheltered here from the worst of it. We know that new technologies are moving forward, and we're moving forward to net zero, towards net zero, which will mean changes on how we generate and how we use energy. It's important that we approach these challenges in a joined-up manner and with a view to our long-term energy requirements. And the energy strategy that the Deputy is pushing forward, making me push forward with, will help us to do that. It's going to cover a number of ministerial portfolios, as well as other organisations outside of government. And as the Minister with responsibility for an energy policy, my role is something of a convening one, bringing the different stakeholders together. It's important that we're going to look at all aspects of the energy landscape. Our approach to net zero is already set out in the carbon neutral roadmap. However, areas such as resilience and affordability, which have already been mentioned, are equally important, and we've seen that in the last few years. They will have to be absolutely considered as part of the strategy. I'm aware there have been calls for greater regulation of the energy market, and while it's not too early to say one way or the other, an energy strategy will approach this question in an objective and evidence-based way. There's plenty of work going on in the energy space, much of which will contribute to the new strategy. We've been taking action to improve our energy resilience by responding to recommendations made last year by the CNAG and referenced by the Deputy in her opening speech. As I said, work continues on delivering the carbon neutral roadmap, including schemes such as low carbon heating incentives and helping islanders with the transition to low carbon heating. The plans for offshore wind are also being developed, and I will be bringing those back to the Assembly later this year. The amended timeline that the deputies kindly agreed to that I proposed in my amendment is part, but certainly not wholly, because of the work on offshore wind. The decision on whether we proceed with plans for a wind farm is closely linked to an energy strategy. It therefore makes sense to bring the wind work back to the Assembly first, with the energy strategy following, once that important decision has been made one way or the other. That said, there's still other energy strategy related work underway, and it's happening now, both this year and next. And members can rest assured that important evidence gathering work, stakeholder engagement and discussion, and key areas and tasks related to energy are being addressed in parallel to the development of the energy strategy itself. In conclusion, sir, I'd just like to say this work is already part of my plan, and I'm very happy to support the Deputy's proposition, albeit amended very, very slightly by my amendment. Thank you, sir.
Indeed. Deputy Scott.
Thank you, sir. I have limited delegated ministerial authority in the area of sustainable economic development, but as the Minister's not here, I just thought I would at least say my thoughts on this. And I think it's a really on-point proposition. The need for cohesion in this area that's been mentioned, but also the wish to avoid over-regulation. One thing that I have been raising and discussing separately with energy providers and indeed with the Chief Economic Advisor as a whole is simply the concept of modelling. Because we don't seem to do a lot of that or see a lot of that in terms of assessing our needs. And even when it comes to policies, simply starting with what a needs analysis, a gaps analysis. These are the sort of terms I find myself using these days. And we need to anticipate so much when it comes to our energy strategy because the technology is changing, demands and what we see in terms of demands on energy, whether it's from the internet and other areas need to be anticipated too. All of these are really important in terms of developing something that's going to work for the island so we can be resilient, so that we can support, hopefully, a growing economy whilst making it as environmentally friendly as we might. I'm briefly going to touch on, notwithstanding the fact that Deputy Osoof withdrew his amendment, I actually think that the points that he was raising, insofar as there is a contract coming up, and there are points that should be considered, I think that's very much worth mentioning. Some of the things that should be considered in terms of some of its details. Obviously, the actual renewal or the new contract is going to be happening before the anticipated date of this strategy. So it does seem that the choice that he took and the work that the Minister for Infrastructure is going to do is the appropriate way to deal with this. So I'm very happy to support this proposition, sir.
Does any other member wish to speak on the proposition? No other member wishes to speak? Deputy Osoof?
I was assuming on a matter of such public importance, maybe members don't think it's important, but I'm grateful for the previous speaker having said at least something that was supportive of what I was trying to achieve. I'm grateful for that as an Assistant Minister, and I think that I would like to think that the Minister for the Environment was going to do this anyway, but if it's needed a proposition by the Deputy to put beyond doubt that commitment in writing and to deal with the generality of the issues concerning a fuel strategy, sir, it cannot be the case that we as a State Assembly do not raise the issue of gas as an issue for islanders in terms of their fuel. And we are well aware that there was loss of life. I know that I'm not going to stray in any way, sir, into a court case. However, at the same time, it is worth noting that the gas in the island's network is propane. It is not natural gas, which is the gas that consumers that would come here from the UK are used to, which is natural gas, which means it percolates through the environment. The gas that is through our pipes in Jersey is propane, and it is a gas that lies and sits at the bottom and does not rise and evaporate into the atmosphere. And when I asked the Minister for Infrastructure this morning about the claim that I understand the island energy firm are making that they're going to be, there's a great future for gas in Jersey, I investigated what that great future was, and I know that you can get other biofuels, but what members were told was wrong. There is no chance that the minister is going to tender his biogas because he's using it. It's called regenerative economics, I think, donut economics and all the rest of it. It's good old-fashioned reuse and recycling. He's making some gas and he's using it to power things, which is reducing the costs of operating his infrastructure plant. And the previous minister will understand that, and all those that have been on public works. And resource recovery was once a word for, I think he's resourcing and recovering, sir. So what does that mean? It's said in jest. The minister and the department is doing good work in Belazan, and they're recovering that gas and using it for good purposes, cutting costs of fuel that they would have to buy elsewhere. So then what is the future for Jersey Gas? Well, I don't know. I don't know any other member that knows. And I've heard so many stories over so many years, but gas, as members will know, is the most expensive fuel by a country mile. It is the one that's on doorsteps in St Saviour, where we do have a gas network extending into the parish and into estates. The people that we speak to say that they are being crippled by the cost of gas because it is so expensive. And when you speak to the people that are using gas, they're often tenants. And the reason why that they have gas installation in their properties is that Jersey Gas provided the gas in central heating system for free for the developers. So they didn't have to pay it. And so Jersey Gas then provides you with a free installation of central heating and all the radiators, and then it's to the tenant to pay the costs. Well, then the costs are enormous, so tenants are getting are worse off. So there's lots of issues in relation to landlords and tenants, and it's not just the things that we hear in the States. There is a problem with the cost of different fuels in Jersey, and Jersey Gas is the worst, and it is also the most dangerous. And whether or not the matters that are before in another place are proven or otherwise, there is no doubt that there is a serious risk when dealing with what is a far more dangerous material in those gas pipelines than in any other places that have natural gas through their pipeline networks. And so I would ask the Council of Ministers in their considerations of the right energy types, I think that it is probably likely, sadly, that the island's going to be faced, and the Council Minister is going to have to be faced with some big decisions about, there are choices that the government, we ultimately, because we make some of those decisions as the Assembly, are going to have to make about what fuels are available in Jersey. What's the right mix? And is there a future for some of those fuels? In a net zero world, we would be all electric. And so it must be the case that there must be some urgent, and I know from the real concern, members will not, it won't have escaped a member's notice to see lots of roads being closed here and there, signs appearing outside properties. There was one up Trinity Hill just 2 weeks ago, another gas leak, because so many houses have no longer been connected to gas because they cut it off. They can afford it, they change to another fuel. If they've got a garden, they can put a central heating oil thing, they will do that, particularly when the cost of heating oil came down because of the competition issues I raised earlier. People can be empowered to make choices if they can, but many of the people that are on gas can't because they're tenants. So we, as the public, need to make some real consideration for those householders that are really shackled with gas. And it's dangerous. And we must not escape the fact that it's dangerous. It is dangerous. And Jersey does not have, we were supposed to have an energy debate when I moved the proposition came today. Deputy Jean and I said, oh, we can have a proper debate on energy in one sitting. And we were going to have the amendments to the gas law debated. They're important amendments, and that is an issue for another day. But it does highlight the real importance. And I don't like being a broken record, sir, but gas is one of those things that I've raised in this assembly on many occasions and written memorandums to as an outgoing minister, pleading with my successor minister to take necessary precautions in the public interest to safeguard the ability for Jersey Gas to do a clean-up if necessary. When the Jersey Gas Works site was sold in the town, all the money was sent straight off Ireland. I'm saying that as a matter of public record. People can go to the Gref and get the accounts of Jersey Gas and read it for themselves. That's what happened. I asked a minister that went after me to ensure that he exercised the public interests that's in the gas law. He didn't do it. So the money went off Ireland, so Jersey Gas has got no money. That's in their accounts. So basically, sir, it's really important that we take all of these issues in a balanced and environmental safety and a consumer perspective. And I hope that in now this debate clearly drawing to a close, that all of these important issues, and it's the detail that often sometimes irritates members, and it's the small things that can get into big things, and small risks become big problems, and that's the issue that we're facing, ministers face, I'm sorry to say, with gas. They have some tough decisions, some courageous decisions to take, but they've not got to consider the interests of islanders and not be bamboozled into the commercial interests that are represented by people who make money and sometimes make monopolistic profits out of that because they can. So I say those remarks and congratulating the Deputy for bringing her, putting for the avoidance of doubt that the Council Minister is going to do something, and wish the Council of Ministers well in doing what the Deputy is asking them to do in all respects for the benefit of islanders' purses, the environment and their safety. Thank you, sir.
Deputy Ranf.
Thank you, sir. I've got one main point to make, but I would like to say that I want to express appreciation for Deputy Joseph raising these points. And certainly in regard to the fuel farm, it sits uneasily with me that renewal has happened so much behind closed doors without any real discussion of the implications for it. And I hope that there is a chance via possibly a separate proposition or related to an order to properly debate those issues, because it seems to me from reading the Minister's notes on this that I cannot see any circumstances in which the government would have turned down a new lease, given the reasoning that they applied, and that seemed to me to be very, very disturbing. But the main point I want to make actually is just to switch the nature of the debate a little bit, really, because we've talked a lot about the problems that an energy strategy has to address and the things that have to be resolved within that. But I think we should also talk about opportunity. And the point about an energy strategy for me is that we are actually, as an island, pretty fortunate. Yes, we have some weaknesses in terms of our need to import fuels and so on, but we also have some pretty significant advantages, partly which derive from our control over what happens in this territory. But also, we do have a terrific opportunity with a wind farm. We are fortunate to have access to an energy resource of the future, available at a relatively low price, in a way that very few places do. I've said elsewhere that had we discovered oil off Corbière 60 years ago, I think there's a reasonable chance we would have been thrilled at that prospect. We would have wanted to leap at the opportunity of exploiting that resource because oil was the energy source of the time. Now we have a renewable energy source also available to us, and it represents an opportunity. an economic opportunity, obviously, but it also is an opportunity in terms of resilience of our economy, resilience of our energy supplies, our energy independence. It opens up new economic opportunities that multiply from having that source. So I would like to just switch the attention to thinking about energy strategy in terms of the opportunity it gives us. We have the opportunity through the energy strategy to address issues around, say, fuel poverty by trying to accelerate possibly the insulation of buildings, having a strategy to reduce energy use where we can. We have the opportunity to take a lead, as several people have said, on net zero, which again delivers a whole suite of new economic opportunities which relate to the future of this island and give us hope for the future, because this is where the world is going, and we have the opportunity to seize some of those new options. And yes, there are conflicts, and yes, there are tensions, but that is exactly what the strategy is designed to help resolve, and to do so, hopefully, in an open and transparent and evidence-based way. So I welcome this proposition. I think it's brought from a good place. It's great to see a minister and a chair of scrutiny working together and in a positive way, and I very much look forward to seeing the work on this progress, hopefully without any further delays.
Very much. Does any other member wish to speak on the proposition? No other member wishes to speak, then I close the debate and call upon Deputy Chair to respond.
Thank you, sir, and thank you to all those members who have contributed to the debate, and I thank the Minister for supporting this proposition, as he knows and has experienced. I will continue to follow up on this work and this area to ensure that this will be the final deadline and it won't get pushed again. He knows how dogged I can be with asking about this, so I will be asking him regularly. Deputy Scott made some very good points, especially around the need for modelling, and this should be part of any evidence gathering data. It was disappointing for me also that Deputy Ozef felt he had to withdraw this amendment, meaning we could not hear other members' responses to what he has raised, including from the Minister, as I think it is relevant, though too prescriptive for this specific proposition. If I was to agree to these amendments, I or we should be just as rigorous in prescribing questions or dictating direction of travel on other elements of the supply chain. And I don't believe that's how a strategy should be developed. But Deputy Ozef did raise some very important points, and Deputy Renouf raised that again. And I think it would have been very important for us to have heard from other members and the Minister in this regard, and I hope that Deputy Ozef brings this in another form for us to have this kind of debate and discussions around the fuel storage and the fuel farm going forward. Deputy Renouf made some excellent points on the opportunity for using this as an opportunity for a strategy and being positive about this, including the future. And as I said, we're rapidly changing globally around energy transformation, and Jersey has a real opportunity with being forerunners, or at least being part of that transition, and also, of course, in reducing energy, being better with energy efficiency and reducing fuel poverty, something that I think is really important that the strategy should develop on. And I don't want to rehash my speech, though I have some very special audience members in the public gallery that I would have liked to have heard my speech at the beginning of this proposition. But I wanted to emphasise that developing a strategy is important, as it will address accumulating issues that we've heard about, such as recent developments in energy affordability or lack of affordability, grid access, storage facilities, safety concerns, and market dynamics. And this demands a comprehensive understanding before implementing any solutions. So a strategy will help us decide where to regulate and where to let the market work. And I'm really glad that the Minister has seen that a strategy in this instance is positive. Sometimes we hear in this Assembly that a strategy is not needed. But this instance, I believe that a strategy is needed, because we need to know where to regulate and where to let the market work. And without a framework, regulation could happen reactively and not strategically. So if we want our energy system to work for everyone, we need a joined-up approach that looks at the entire supply chain at every stage and guided by the clear analysis around the pillars of affordability, safety, reliability, fairness, and our climate commitments. So I'd like to encourage members to vote to support this proposition. And I call for the appeal.
The appeal is called for. Invite members to return to their seats. The vote is on Deputy Jones' proposition, evidence-based energy strategy P11, and I ask the greffier to open the voting and members to vote. Members have had the opportunity of casting their vote. Then I ask the greffier to close the voting. The proposition has been adopted. 43 votes pour, no votes contre, no abstentions. The next item of public business is the draft single-use plastics restriction Jersey Amendment number 2, law lodged by the Minister for Infrastructure. The main respondent is the chair of the Environment, Housing and Infrastructure Scrutiny Panel. I ask the greffier to read the citation.
Draft single-use plastics, etc. restrictions Jersey Amendment number 2 Law 2000, a law to amend further the single-use plastics, etc. restrictions Jersey Law 2021. The states, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Minister.
Thank you, sir. Sir, I hope that this is one of the most straightforward amendments to legislation that will come before this Assembly. It is to amend. I should be careful what I wish for, sir. Yes. It is to amend an incorrect reference which has come to light in the single-use plastics law. The amendment to the 2021 law, which was adopted by the Assembly in December 2024 and has now received royal assent, unfortunately makes an incorrect reference in Article 7 to the Royal Court, when this should in fact be a reference to the Magistrates' Court. This amendment makes that correction. It would of course have been preferable if this had been picked up prior to the amendment law being adopted last December. So this is an inadvertent mistake that happens and it falls into that category, and I move the principles. Thank you, sir.
Principle seconded.
Yes, sir.
Does any member wish to speak on the principles? Those in favour of adopting the principles kindly show. Those against? The principles are adopted. Does the chair of the Environment, Housing and Infrastructure Scrutiny Panel wish to scrutinise this matter?
After serious consideration, we've decided not to. So.
Okay, right. How do you wish to propose the articles, Minister?
En bloc, sir.
Are they seconded in second reading? Does any member wish to speak in second reading? Those in favour of adopting the articles in second reading kindly show. Those against? The articles are adopted in second reading. Do you propose in third reading, Minister?
Yes, please, sir. Can I thank members for their support? Thank you.
Are the articles seconded in third reading? Yes. Does any member wish to speak in third reading? Those in favour of adopting in third reading?
Appel, please, sir.
The appel is called for. I invite members to return to their seats and I ask the greffier to open the voting. If members have had the opportunity of casting their votes, I ask the greffier to close the voting. The law has been adopted in third reading, 42 votes pour, no votes contre, no abstentions. The next item of public business is the Organ Donation Memorial, lodged by Deputy Stevenson, and the main responder is the Minister for Health and Social Services. And I ask the greffier to read the proposition.
the states were asked to decide whether they are of opinion to request the Council of Ministers to take the necessary steps to ensure that a public memorial to organ donation is provided as part of the planning commitments of the acute hospital at Overdale or any subsequent hospital developments to the Percentage for Art scheme.
Deputy.
Thank you, sir. I'm pleased to bring this, what I'm also going to call a simple proposition, to the House. It seems to have been a good luck charm for the last two speakers, so I'm going to say it myself. But hopefully a positive proposition as well, where we can hopefully send a clear message from this Assembly, not only to the families of donors who've already given such a precious gift, but to those who may go on to in the future, and really to say how grateful we are to them. I also believe this is an opportunity for our community to keep the conversation around organ donation going, as well as to encourage healthy conversations around death and personal wishes. By way of a bit of background, I have some personal experience. My late mum was an organ donor 20 or so years ago. And that experience for my family, although obviously very difficult and unexpected at the time, it was, to use the word again, a simple decision for us. We were most worried about raising the discussion actually with my nan. She was a very religious woman, but actually she was one of the most vocal supporters of that decision. We knew my mum's wishes very clearly. She carried an organ donor card. For us, it was simple. I know that is not the case for everybody. I absolutely acknowledge that. It's a very sensitive subject. But that is just some personal experience, which then led me in my years when I started working as a local journalist to have a real interest in this area and to start asking some questions around Jersey's experience. And it was at the time that this Assembly was also starting to talk about organ donation. And former Deputy Roy Laharicia was bringing propositions to the Assembly to talk about looking at the way Jersey's policies around organ donation worked. I think Deputy Tadia was also involved as well at the time. And then later, the former Health Minister, Andrew Green, was responsible for bringing proposals to this Assembly for an opt-out system for organ donation. And that system has now been in place since April 2018. And that law means that consent is implied unless specified otherwise. So just to carry on with the background story so you understand where I'm coming from, during that time, I, as a journalist, interviewed lots and lots of families with lived experience of organ donation. That included those who'd made that difficult decision as they were losing a loved one to donate organs, to those who were waiting for transplants themselves, to the families of transplant patients, and many, many others. And the discussion around having a memorial came up a lot. I've continued to talk to many of those people in the years since, and still do with some of them, and it continues to be a discussion point. Jersey still doesn't have a memorial, and we do have conversations that it would be good to have one. I would also say that since those debates in this Assembly, in many ways, actually, the conversation locally around organ donation has gone quite quiet. And it would be nice to start talking about it again and to have some kind of permanent reminder which can encourage people to think, perhaps when they're passing or when they see a statue or a piece of art or whatever it could end up being. Other jurisdictions have memorials around the world, particularly in the UK. There's a UK National Memorial in Staffordshire, and anyone who's had the opportunity to read my report accompanying the proposition will see that there are links there to some of those examples of memorials that exist. They are very varied, and they can be anything from a piece of artwork on a wall to a statue to a whole memorial garden in the grounds of a hospital or elsewhere. This proposition isn't asking for any details to be agreed. It's not saying where a memorial should be, what it should look like, even how much exactly should be spent on it. It's just asking for this Assembly to agree the principle.
and the principle that the memorial should be funded and developed as part of the new hospital's commitment to public art under the percentage for art planning obligation. So how will it work? The mechanism for such a memorial to be created already exists. I've engaged with the Health Minister and the hospital team, who've confirmed that it would sit nicely within the therapeutic arts strategy that they're already developing. That would include public consultation, engagement with those with lived experience and more. And I have reassurances from them that it would all be very sensitively carried out. I know that's something that the Minister is very, very aware of, to make sure that that happens. The funding also already exists as part of that work. I'm not asking for any new money to be allocated here, or, as I say, for a figure to be put on the memorial at this stage. So I just reiterate that I am grateful to the Minister and his team for their engagement and for their positive response. In which case, some may ask, why should we debate it at all? And I just want to say to that, really, that it's, as I outlined at the beginning, it gives us an opportunity to have a positive, healthy conversation around donation and talking about our wishes after death. We also know, particularly when it comes to new hospitals, things don't always necessarily go to plan, and we are only a year away from an election. I would like to have a States Assembly decision to back up this principle, which hopefully can transcend assemblies if it should ever need to be. Hopefully it won't be, but just in case. I would also say, like to thank Deputy Balash as well, who suggested when I was developing this proposition that I add those who donate blood to this proposal as well, and I think that's an extremely good idea. Those who donate blood do make an important contribution in our community, and they save lives as well. And I would just add, of course, organ donation doesn't just apply to those who have died. We do have living donors as well, stem cell donors, people who donate kidneys, and all sorts. As of March, there were 7 islanders currently waiting for transplants. That's 7 people in our community who would benefit from donors being found for them. 7 people whose lives are potentially in danger if donors aren't found for them. Sir, I recognise that organ donation can be a very sensitive subject, and I have no doubt that members recognise that too. Not everyone will agree with donation, and not everyone will want to be a donor, and that's absolutely their right. But we also shouldn't be afraid of talking about it. And we certainly shouldn't shy away from publicly recognising, in a sensitive and, of course, appropriate way, those who have given the gift of life to others in this way. Sir, I make the proposition.
Is the proposition seconded? Does any member wish to speak on the proposition? Deputy Bennett.
It may be helpful for me to speak at this point, sir. So as members will know, the Council of Ministers and I are very happy to support the Deputy's proposal to take the necessary steps to include a public memorial to organ donation as part of the Percentage for Art scheme at the new hospital. I'm sure we all recognise the profound impact of organ and tissue donation in saving and transforming lives. And in Jersey, both deceased and living donors, along with their families, have made extraordinary contributions to the health and well-being of others. So it's certainly right that their kindness should be recognised and remembered. The new hospital scheme has a strong commitment to public art, sir, and work is already underway to develop a therapeutic arts strategy, so the timing of this proposal is particularly appropriate. As Deputy Stevenson has already explained, incorporating public memorials to organ donors is a pretty common feature in the development of percentage for art schemes within healthcare settings. So, given the sensitive nature of organ donation, the fact that it's well recognised, the Council would just like to emphasise the fact that any initiative of this nature must be handled very delicately to ensure it's both impactful and respectful. It's crucial that the memorial doesn't intrude or distress current patients who may be facing life-changing or life-threatening conditions. So it may be helpful for me to tell members that we've got great confidence in the programme's art advisor, who's going to lead this aspect in the art strategy in collaboration with the new hospital team. This particular arts advisor has successfully integrated organ donation memorials into healthcare arts strategies in the past, including one at Great Ormond Street Hospital. And I think this experience will help the memorial to be developed through proper consultation and engagement and then delivered sensitively and appropriately. So, thank you.
Thank you very much. Deputies, any other member wish to speak on this proposition? Deputy Tadier.
Thank you, sir. The Speaker did reference me as somebody who was shown an interest in organ donation. Really, there were others who were, like Deputy Lauricio, I think was quite maybe ahead of his time in the Jersey context for pushing us towards the ultimate opt-out system that we have today. I was looking at a very good quote, in fact, from not this current Dean, but a previous one who made the point about when Deputy Martin was the Assistant Minister for Health. He said that there were many of us who would love to see an opt-out system on the very sensible ground of love thy neighbour, as when I do not need my kidneys anymore, I'm not going to need them in heaven either. Somebody else is very welcome to them. Would she accept that from me? And she said, I thank him for his donation. I don't think he was quite donating his kidneys at that point, but I think the spirit was well intended, sir. And I was also quite moved by the Deputy Stevenson's personal story. There's often a personal story behind these areas, sir. I'm only going to speak very briefly because I'm interested, of course, in organ donation, but I'm interested in sculpture in particular, and I think that we don't necessarily have enough of it. And there was a time, of course, in Jersey pre-1990s when there was not a lot of modern sculpture that was being created. There was the establishment of the Public Sculpture Trust. I would like to ask, I don't know if this is something the mover of the proposition could answer, but certainly from a ministerial point of view, I metaphorically, figuratively look at the minister with responsibility for island identity, and I would put the question to any of the ministers or assistant ministers at economic development, because that's where culture lies now, about finding out whether or not the Public Sculpture Trust still exists, whether they could have some input into it. I was also asked a question very recently by some tourists, in fact, about whether some of the sculpture in Jersey was done by local artists, and I really had to scratch my head because certainly in St Helier, I don't think that is the case. We've got a very good artist in Derek Tristram, who timely, in a sense, with the 30th anniversary of that Channyland, when it hit the rocks by Corbière, was only, I think, this week. He's a very well-known sculptor, and the sculpture that stands, of course, at Corbière is one of his works. So I'm not saying that necessarily this should be something which is commissioned from a local artist, but I think expressions of interest should be sought from local sculptors because they do exist over here, and it might also be nice for them to have input. But similarly, it should be something that speaks, I think, to as wide a variety of people as possible, but primarily those who have donated, sir. I'm also minded, sir, that now we're all potential donors, because if something happens to us, our organs can be used if they're in such a state as to be of use to anyone else, sir. Hopefully that will be the case. But in the past, of course, it was an opt-in system, and very few people were opting in. I think we need to give special recognition to those who did make that decision, whether in life or for their organs to be used on their expiry, sir. And I too am pleased that blood has been included. I must admit, I'm not a blood donor, sir. I don't particularly like needles, and I don't particularly like to give blood unless I need it for specific reasons to do with my own health. So I have full admiration for those who do, but I also can't help chuckling. As soon as I hear blood donation, I'm taken back to the blood donor sketch from Tony Hancock, sir, when he says, "A pint? That's very nearly an armful, sir." And so I'm mindful that actually even giving blood, which is so vital for so many people, is still quite a big ask of some of us. And who knows, sir, I may well even get round to that one day.
Does any other member wish to speak on the proposition? Connie Tarbison, Saviour.
Thank you, sir. Yes, this is something I can support, sir. And I'm also a great supporter of blood donation and organ donation. I can't donate blood anymore, apparently, because being on medication, anyone that has my blood will light up like a Christmas tree But apparently, being teetotal most of my life, my kidneys are in very good condition. So people are more than welcome to have those. So not much else worth salvaging, I dare say. But this is something I can support, sir, 100%. Thank you.
Does any other member wish to speak on the proposition? No other member wishes to speak. I close the debate and call on Deputy Stevenson to respond.
Thank you, sir. And I'm grateful to those members who've spoken as well. I'll just reiterate once again my thanks to the Minister and his team. It's very nice to have something to so clearly agree on with the Health Minister. Thanks also to Deputy Balash, as I said earlier. Those people who I didn't actually say a thank you to in my opening speech, I think I neglected to mention, were also the medics actually who work in this area, because it's certainly not an easy job to do. They're not easy conversations to have with people, and they're caring for people in some very serious situations there as well. And I know we have a small but very dedicated team who have a specialist interest as well in organ donation and will make it possible, because Jersey is slightly more complex than places on the mainland, although I don't like to say that, but it, you know, being on a mainland helps. So it's slightly more complicated for Jersey, but they do make it happen. And of course, a thank you to all the donors and their families and loved ones who've supported their decisions over the years or will go on to in the future as well. Just to pick up on a couple of Deputy Tadier's points, many of which I agree with, and I think we've had discussions now and again similarly. The Public Sculpture Trust is a conversation I tried to start at one point to try to find out actually myself if it still exists. My understanding was something similar was trying to be developed. Whether it's actually got off the ground, I'm not sure, but perhaps that's something that the Deputy and I could follow up with the Economic Development Minister and others to find out as well. I will admit I did briefly consider whether I should include a stipulation that it should be a local artist in the proposition, but ultimately decided not to. And I know the other area that we've spoken about, the Deputy and I, is that we'd like to see more public art recognising women, but also perhaps from female artists as well. So just really to conclude, finally, I would just say that for anybody inspired today to find out more or to take any kind of action, there are various things that actually we can do today as a community. We can still register our decisions to donate or to opt out, and you do that by visiting the National Organ Donor website, because Jersey is a part of the National Register. We don't like to think of ourselves as part of the UK. We're not part of the UK, but when it comes to the Organ Donor Register, we absolutely are. That's where islanders waiting for transplants, that's where they would get those transplants from, and where anything donated from Jersey would go into that system as well. So you can register, you can also opt out from there as well. You can talk to your loved ones about your wishes and theirs too, and I think that that's something that as a community we're talking a lot more about, and we did in a recent debate about end-of-life care and wishes as well. You can also become a living donor, and you can join things like the Anthony Nolan Register for stem cell donation, and that's a very good way to start that if needed. You can also donate blood. So thank you. I'm very grateful to members for listening, and I ask for the appel.
Let us call for, invite members to return to their seats. The vote is on organ donation memorial, which by Deputy Stevenson. And I ask the greffier to open the voting and members to vote. If members have had the opportunity of casting their vote, then I ask the greffier to close the voting. The proposition has been adopted. 42 votes for, no votes contra, no abstentions. Well, the final item of public business is increase in assets and savings threshold for the Affordable Housing Gateway lodged by Deputy War. The main respondent is the Minister for Housing, and I ask the greffier to read the proposition.
The states are asked to decide whether they are of opinion to request the Minister for Housing to increase the qualification criteria for savings and assets allowable to enter the affordable housing gateway to £200,000 for individuals of pensionable age.
What time your point was? He said they're free from now, any time onwards.
I think Deputy Lehegra has a microphone on, sir.
Right, thank you very much. Not quite sure if that's a fine or I have to ask what the point of order was, but it's an echo indeed. Yes, Deputy.
Thank you, sir. I've read carefully the Minister's report in which he says that my proposition should be rejected by this Assembly. He does, however, agree with its principle and apparently wants to go further. The reason I am pressing on with my proposition is because of the absence of data. I know the Minister has said in the past that he is not a data-driven politician and that he goes by experience rather than data. That's fine in theory. However, when there is more demand for resource than there is supply, you need data to inform your decisions, particularly when we are dealing with the provision of homes for islanders. I have tried very hard in my proposition to use the evidence that is publicly available to inform the numbers to which I refer. I've been very cautious in my approach and see my proposition as action today with a longer-term policy being developed by the Minister when he has the data to inform such policy. Dare I say, a roadmap. I don't understand what has driven the Minister to make such an extreme move to completely abolish the savings threshold without providing any evidence as to its ramifications. It brought to mind that famous sequence in the movie, and I know I'm going to get into trouble here, sir, The Italian Job, and the complete destruction of the van when...
No.
Okay.
Unless you're prepared to edit it significantly.
I will edit it significantly, but I think we get the gist here, sir. So The Italian Job and the complete destruction of the van when testing the level of explosives needed for the heist. It led to the infamous Michael Caine line, "You're only supposed to blow the doors off." That is the purpose of my proposition. The data informs the next step. I don't want to blow up the housing gateway. The proposition came about because of an encounter with one of my constituents. The more I thought about the move, the more it became apparent to me that we're forgetting about many of the people who have given their life to this island, but now find themselves just existing despite owning their own home. Frightened to put on the heating, unable to pay for the upkeep of their home, and uncertain as to what the future holds for them, simply existing day to day. Yet the Minister says in his report that these individuals are sheltered from the high cost of housing. I disagree and believe that choosing between heating and eating is unacceptable in our island. Consider the petition brought recently to the Assembly with 5,000 signatories to exempt Social Security old age pension income from tax. We as an Assembly chose to reject that, but it has left many pensioners feeling incredibly aggrieved. Today we can start to redress the balance. I object to the Minister's line that the proposition presents a false argument as it conflates minimum wage and state pension. The point I make is that for one group of people, £466 is considered a living weekly wage, whilst for another group of people, because of their age, apparently, just £286 is sufficient. Are we tolerant of pensioner poverty and age discrimination? If not, we should have a target figure for a living pension, which is as important as a living wage. I disagree with the Housing Minister's approach. There are 5,200 pensioners in relative low income after housing costs. That's a big number. And if we were to allow all of them immediate access to the housing gateway, it would be overwhelmed. Simply put, we'd be giving hope where there is none. This is where the data is so important, because the cohort who own their own home and have no mortgage could be around 988 pensioners. Still a big number. So which figure do we build policy around? 5,200 or 988? Data, data, data. We do know that Andium Homes' build programme is delivering hundreds of new homes for islanders. Therefore, it is reasonable to open access to these homes to a wider cohort of islanders. But it has to be carefully considered, because we can't help everyone straight away. And it's vital that the most vulnerable are the ones that get support first. By increasing the savings threshold from £70,000 presently to initially £200,000, instead of abolishing the threshold completely, I have calculated that the interest earned from freeing up a home would close the gap between a living wage and a living pension. It has further benefit. Not only are we supporting some pensioners who own their own home out of poverty, we are also potentially freeing up much needed family homes for the next generation. Today, I ask the Assembly to support my proposition so that we can make that first tentative and prudent step towards giving greater security to a cohort that feel overlooked. Let the Housing Minister go away and develop his policy for all the reasons I've given, but most importantly, let's do something concrete today to make a difference to hundreds of islanders today. I move the proposition.
Is the proposition seconded? Deputy Mayor.
Thank you, sir. In my response, I will try not to be too harsh against the proposer of this proposition. There will be plenty of time for that tomorrow at 5 o'clock at the Pomdor at the Question Time event that I'm very much looking forward to sharing a platform with him at to talk about the housing crisis. But sir, it is the case that in both his report and in his speech just now, the Deputy has made a litany of statements that I believe are either extremely misguided or very seriously misunderstand how the system works and what the implications would be from what he is proposing. But I do agree with a couple of things that he said, sir. In particular, sir, he said that it's vital that the vulnerable get help first. I completely agree, which is why we must reject his proposition, because it opens the door to doing the opposite and allowing people who have objective housing needs in one sense, but hundreds of thousands of pounds in the bank to potentially leapfrog over people on the list who also have those housing needs, but nothing in the bank in order to help themselves. And that is the fatal flaw in his proposition. I also agree with him when he says, let's do something. And so I stand poised to do something, which is that if the Assembly agrees to reject this proposition, I have a ministerial order waiting for me to sign, which would change the social housing eligibility criteria to abolish entirely the asset limit for applying to be on the housing gateway, not setting a new limit of £200,000 exclusively for people of pensionable age, but abolish them entirely, and instead say that the level of savings would be a consideration into where an applicant is banded on the gateway, and if they have over £80,000 of assets, that it would be presumed that they would be in band 3, unless upon determination with the Affordable Housing Gateway, it was felt that they had needs above and beyond that that were so significant that they needed to be placed in a more urgent banding. And that might be because they have savings that will need to be spent on particular things because of other needs that they may have. So that would prevent anyone from being denied access to the gateway because of their assets and savings, but would provide a much more tailored and bespoke system for those people with substantial assets so that they can be placed in a banding that reflects their need, bearing in mind that some of these people will have very substantial assets, which it is not fair to have them leapfrog over people who are in dire financial need as well. So he calls that an extreme move, which I think is ironic because he does say at the end of his report, he says we shouldn't be frightened to be bold, but it sounds like he's actually terrified of such a prospect, and chose to make much of his speech about data, which we have to call that what it is, sir. It's ironic because with his proposition, he has no data to suggest what that would do, and criticises me on the basis saying that I don't have data. Well, so it's impossible to manufacture data for something that you don't know. So I don't know how many applications to the gateway there would be if Deputy Waugh's proposition is accepted. And I don't know how many applications to the gateway there will be if the proposition is rejected and I go ahead with my ministerial order. But what I do know, sir, is that if there are applications as a result of Deputy Waugh's proposition, the rules that would come about as a result of that would allow people with a substantial amount of money, hundreds of thousands of pounds, in fact, to leapfrog over people who don't have any money at all, whereas what I am proposing will stop that from happening. It will allow people with a very generous savings and asset threshold of £80,000, which far exceeds many of our neighbours, and good, sir, it should. We should be generous with those limits. What I'm proposing will not deny those people access to the gateway. They will be able to get on it, they will be able to apply, and they'll be able to go to the Housing Advice Service and the team of the gateway, and we can look at them and say, okay, if you are applying because you'd like to be in social housing, but it's not a particularly urgent need, that's okay. We can band you in such a way that those that are more vulnerable get the help first, as Deputy Waugh said he wanted to see. Or if they have particular needs above and beyond that, we can say, okay, actually you shouldn't be denied quick access to housing here. We can open that opportunity up to you where currently it is closed. So I ask members to reject the proposition from Deputy Waugh on the basis that it is flawed. He makes further statements in his report that I don't want to dwell on too much, but we do have to refer to them so that the fact is on the record. But in the very first line of this, he says part of the intention of this is to reduce poverty levels in our retired population. So it will not reduce poverty by one single case if his proposition is adopted. It just won't, sir. But if I can very briefly, sir, just address part of the narrative which he makes reference to in his report and made reference to in his report about the toleration of pensioner poverty. Sir, I will take no such accusation because of my long record of supporting pensioners in Jersey, opposing measures that exacerbate pensioner poverty and supporting what we can do to make life easier for pensioners, sir. I opposed the abolition of the pensioners' enhanced tax allowance. We opposed the abolition of the pensioners' Christmas bonus. We fought and succeeded in saving it, and we fought to increase it. We fought to expand the community cost bonus to encapsulate more pensioners into that definition. We introduced the health access scheme, providing cheaper access to healthcare for pensioners, and we have a raft of other policies that we fought hard for, succeeding sometimes, not succeeding in others, specifically to alleviate poverty for pensioners. But so the comparison between those receiving a state pension and those on the minimum wage is a flawed comparison, because those are the support mechanisms that in some instances will be provided in completely different contexts. And I will say that it does nothing to advance our dialogue politically on how we reduce poverty in our society by pitting one group of people who are vulnerable to poverty against the needs of another group of people who are vulnerable to poverty. We should treat in-work poverty as seriously as we do pensioner poverty and not use one as a stick to beat the other with. Sir, that is, I think, the case that I would like to make to members, to reject this proposition because of its flawed nature, because of the unintended consequences that so obviously will happen as a result of it, including the injustices that it will create by allowing people with substantial recourse to finances to get more urgent allocation in housing for those in dire financial need, and instead take the option that I propose, which is removing the barrier of assets entirely for access to the gateway, but instead regard it as an issue for banding, so that those who would like to go into social housing but don't have a desperate need can have a pathway established for them doing that. But those who do have assets but who have other needs that will complicate things for them, that they can be banded appropriately as well and not be denied access to social housing as they arbitrarily would be now. I think that that's a much more pragmatic solution. It's better thought out than what the Deputy proposes, and it will enable that what I anticipate to be a relatively small number of people to engage with the housing gateway, whereas right now they wouldn't even be able to go through the door. The moment it's clear what their assets are, they will instead, because of what I'm proposing, get through the door, have a conversation and a pragmatic solution found for them. So, sir, I ask members to reject the proposition and support me in doing something that I think is smarter and more pragmatic and will actually help people without those unintended consequences.
So I wonder if I could ask for a point of clarification.
Do you give way for a point of clarification?
Yes, sir.
Thank you. Did the Minister say he had already made an order, or he would be? Because I think the gov.je website appears to suggest that it's already happened. And will it be happening even if this proposition succeeds, or is it only if it's defeated? Thank you.
I thank the Deputy for giving me the opportunity to clarify that, and I apologise that the gun was jumped on that. That was a change of minds that I had during this process. I have not signed a ministerial order, but I have one ready to draft, and if the Assembly does give me the mandate to do that by rejecting this proposition, then I would get on with it very quickly.
I'm sorry, sir, the last part of the clarification, if the proposition is approved, would it still, the order still be signed? Because theoretically there could still be people beyond 200,000 who may want to have their name.
I think I would kind of see them as contradictory. I certainly think I wouldn't be in a position to do that in the short term. I'd have to give that much greater thought and would probably want to amend it slightly. I think as it's framed now, I don't think it's consistent to do that. If the proposition is accepted, I think I would have to pause that and find a different form of words or actions on it.
Well, I have, sorry, was this a point of clarification?
To speak.
Just to speak. Well, I have listed to speak Deputies Moore, Ozef Tadier and Alex Curtis. So Deputy Moore.
Thank you, sir. I'm grateful to Deputy Stevenson for raising that point of clarification, because I think it has helped to shine the light on what was something of a perplexing speech from the Minister just there. It's actually what the Minister is suggesting is that if Deputy Waugh's proposition is not agreed today, then in fact he will be opening the opportunity of achieving social housing to people of all social or of all economic brackets, which is, I think, something more akin to the system that we see in a city like Vienna, where I believe some ministers have visited over recent years, where we have social housing available to all people, which of course, if it's available, is a good thing. But the point that confused particularly about the Deputy's speech was that we currently have a banding system that is extremely extremely clear for people applying for social housing. So if the Assembly does support Deputy Waugh's sensible proposition here to introduce a limit of £200,000 worth of savings, then those people will also be considered under the banding system and placed into a tier according to their needs as they're assessed when they go through the housing gateway. So I believe that Deputy Waugh is making a sensible step here. He's acknowledging the importance of saving for our old age. So I believe personally that we should all be encouraged more by government incentives, perhaps, to save for our old age. It's a responsibility that we all have to our community around us, so that we are not unnecessary burdens on future governments economically if we make poor decisions for ourselves during our earlier years. And increasing this bracket to £200,000 from the current limit, I believe sets a different tone to people, rather than what they are often told is go away when people are in need. I am aware that they are often told when they seek support and alternative housing, they are told, no, go away, spend your money until you are within the threshold and then we will be able to help you. So that does not encourage saving, that does not encourage personal responsibility, and it is not the right thing to do. People should be able to do, if they are able to, put some money aside in order to do that. And I believe that Deputy Waugh is doing a sensible thing here in increasing that limit and giving the right message to people of a level of savings that is reasonable in order to access our social housing system. And so, sir, I will most certainly be supporting Deputy Waugh today, and unless, of course, members believe that everybody of every income bracket should have the opportunity to benefit from social housing, then I also hope that all of the Assembly will be supporting Deputy Waugh. Thank you.
Very much, Deputy Ozef.
Thank you. Thank you, sir. I rise with a heart brimming with conviction to champion Deputy David Waugh's proposition, sir. I think it is a clarion call to weave compassion into the fabric of housing policy. The Deputy's proposal seeks to lift the affording housing gateway savings and asset thresholders for pensioners. It's not a bureaucratic tweak, sir. It's a lifeline, a potential really useful and valuable lifeline to those older age, the silver surfers, they call them, sir. I was 55 recently. Does that? I'm over 55. Does that mean I'm over? No, I don't know, sir. I feel young anyway. But it's so important, sir, that there is a recognition that we need to develop almost a bridge to dignity for those islanders who are ensnared in the paradox of being asset rich and in living in penury. With utmost respect, sir, I do say that genuinely because it is not a pleasant assembly, sir, when ministers choose to have a go at their predecessors in the way that sometimes people are. I'm going to not be like that. I want to be encouraging. I think the Deputy Waugh's proposal should have been embraced by the minister. I think Deputy Waugh's brought a really important issue to members' attention, and to simply be subjected to this sort of them and us caricature is not really becoming of this assembly. It's not what I've been used for, and it's not what we stand for. As I've said before, sir, we're all on the people's side, and we should be welcoming, as a minister or a backbencher, we should be welcoming a backbencher's proposition, and I can see the minister tutting and not liking it. But with the utmost respect, the ministers were, whilst perhaps well-intentioned, they do cast a shadow of misapprehension over what is a noble, and I thought, when Deputy Waugh asked me about it, I thought, what a brilliant idea. That is exactly the solution to so many St Saviour residents who are in that situation of being asset rich and cash poor. And I say respectfully to the Council of Ministers that their policy is to effectively reduce the private sector rental market. That's the policy. We've heard it in this assembly. So where are they to go? We've got a housing market that is in crisis with no transactions. Property's very difficult to sell. I wanted in the budget to bring a relief on stamp duty, one area where we could incentivise older people to downsize. There's lots of over-occupation, awful thing to say really, but apparently elderly people are over-occupying their expensive properties. So what do? We create incentives. And one thing would be to do with maybe to do a stamp duty. Deputy Wall's come up with another brilliant idea, actually. And this is the quandary, sir, and nobody's said this, so I might as well talk about the data. There's actually an oversupply there's actually, all the research that I've seen is that they've actually, what Andium is doing is building lots, and we've heard it lots of times in this assembly, building lots of flats, but I don't think you call flats, so I think they're called apartments, and they're always luxury if you're selling them. And certainly the quality of Andium's properties is excellent, but they have got a lot of apartments in their building programme. And that's probably, I think, going to be, I understand that it's taken some time for Andium to find buyers for the Limes development. I've looked on the innovative website that's been created where you can look at royal court transactions. We can look at them every week now if you pay a fee. I'm not going to give any advertising, but you can look at what the transactions are on the profit market a week after. And I've been looked back and I've seen all the properties Andium has been selling. Now that's very interesting because a lot of them are in St Saviour and a lot of them are 3-bedroom houses. Now, I don't think the Minister is creating enough Andium stock in the 3-bedroom houses that he's selling. But here we have a solution where there is a good supply, excellent, of apartments that Andium are going to have. And there is a problem. Deputy Ward's highlighted it. Other members are nodding. The constables who are close to their parishioners, perhaps in a way that senators might not be, but when they sit there. But they know their parishes. They know there's lots of elderly people. I can see the constables nodding and say, yes, I can see those parishioners that come and say they've got a problem with their rates. They're asset rich and they're cash poor. And what have we got for them? Well, here is Deputy Ward coming up with a solution, and a jolly good one. He's basically saying that they have an access. He's listened to the Minister. He knows that he's in favour of more social housing. Great. Okay. We're building lots more social rented units in apartments. That's a good opportunity for a pensioner to release money that may be able to be put in a bank account to delivered with the care costs so they can stay in their homes with domiciliary care, knowing, of course, that long-term care is a great thing, but that doesn't pay all the bills. And if you've got some cash, then you'll be able to look after. You'll be able to get that weekly support or daily support as that people evolve in life, certainly, but stay in their homes. And that's a great thing. And what we're doing is we're criticising it. I don't think we should. I think we should recognise that there is a group of society that did get on the homeowner ladder many years ago, and rather unkind, really, to say that they're rich, sir. They're not rich. They don't think they're rich. You only get something if you sell it, and if you sell something, you need something to replace it. And what's best to replace it is with a social rented apartment, as Deputy Ward is proposing. And I think that to cast an aspersion, to cast any sort of misapprehension over what is a very good suggestion would be wrong. So I think Deputy Ward really deserves to be commended for coming up with this. And if I may say, Deputy Ward's proposition also is said to conflate the state pension with the minimum wage. It's been branded as almost offensive and a slight on our commitment to quash poverty. The stark truth, sir, is that it's clear, and I know members have probably read this, the Jersey Household Income Distribution Report of 2021-2022 showed that 28% of our pensioners are languishing in relatively low income after housing costs. That's 28% of our elderly community that are in low income after housing costs. The figure in the UK is 18%, and it's 28% here. So is there a problem that Deputy Ward's put his finger on? Yes, he has, and that's the evidence. If members want evidence, they want numbers, they want reasons to do something, there it is. So it's not a unknown. It's not these people don't not exist. They exist. They're real, and they're the ones that also vote for us. And that's not said for any other reason. But they take an interest in this assembly, and rightly so. So this is a real cri de coeur from a deputy, and the reality is that a meagre £286 weekly trail at £178.9 behind the minimum wage salary of £466 as confirmed from the minister. Well, those are the facts. The minister further posits that many pensioners bolstered by private pensions and home ownership enjoy financial resilience unlike wage earners. Well, some bask in security, asset-rich, cash-poor, clutch to homes that are, as the deputy says, too costly to maintain, barred from social housing by a £70,000 threshold, unchanged. Now the minister is saying something completely different, and I really don't understand what the minister's saying. The deputy has brought forward a proposition based on a number, which is what I did the research on whether or not it was possible. Yes, it made sense. Are the people there? Yes, I've seen them on the doorstep as well. They're really alive, as the constables will know. Are they an unquantifiable number? I don't think so. It's possible to some clever stats people to work it out. And anyway, it's possible to set a limit. The minister could, by policy, set the amount of limit. He could put a cap on the amount that would basically be available, and he would just have discussions with Andium to make sure that there was an appropriate allocation of those houses that are available. It seems that this is a proposition that is worth adopting, and if necessary, the minister can take back and improve, not simply ask members to throw it out. The real reality of these people that we are talking about are that they want a better lifestyle, and they can't have it because they're trapped in a home. And it's a big decision to sell that home. They want security. And I think they can get that security with an excellent Andium rental property where they will be well maintained. They won't have all that expectations of a new of capital costs and all the rest of it. It's a really good solution. And also the private sector, if the minister and the council of ministers wants to really do something to create a private sector rental market because it's currently not working, there's a real opportunity to create that as an incentive to create rental properties for more elderly members of society. I think that the reality is that we have not been active enough in recognising that there is this group in society that really has been so far, and I'm sorry, but Deputy Ward really has come up with something. He's identified a group of people that we kind of know exist, but we haven't had a debate about them, and we can do something about it. Andium Homes, over 300 units by 2026, stands ready, I think, to embrace this shift, to take a reasonable number that he could cap. The minister can talk to Andium, have an amount, a maximum. Minister's policy, after all, he can take this and run with it and improve it. And the minister's gravest charge actually is to jump the queue. Well, he doesn't need to do that. Deputy Ward's £200,000 threshold targets pensioners with modest assets, often a single home, yield incomes below the gateway of 33,818 cap for a single person. This is not going to be queue jumping. These pensioners, I think there's 988 by Deputy Ward's estimate of in his excellent report, would meet the stringent income criteria, ensuring fairness when releasing nearly 1,000 homes. And the minister's own plan to simply abolish the savings cap whilst laudable, it courts uncertainty with Band 3 potentially marooning pensioners on endless waiting lists. And I don't think I don't think the minister's response is frankly right. I'll repeat that. The banding potentially maroons pensioners on endless waiting lists. I think is actually not doing what the proposition is wanting to do, and I don't think that's right. But another minister can say if I'm wrong. I'm pretty sure I'm correct, but I will stand to be corrected. Deputy Ward, 200,000 is clear. yielding £173 a week at 4.5% interest, if they have that, offer certainty, brings incomes up to better levels of incomes for those people in society. And basically this will help people that are in cash poverty. And that's a real issue for islanders with inflation having gone up so much. And it frees income for essentials that they're going to have in their later life. It also might catalyse a resurgence of interest in private sector rentals, not only Andean. I'd like members in final just to picture a St Saviour pensioner living in their, I'm going to say it's a lady, it's a 3-bedroom house, a relic of happier times, now a millstone around her neck. Her £180, £150,000 equity bars her from the gateway, and yet her pension barely buys her bread. Deputy War, that's a real person, they really exist. Let us think about those real people. That person really exists. I haven't taken anybody, I've imagined it, but that person, members know, that caricature, that example is a real person, and they exist. And we should do something about it because we can. Deputy War offers us a salvation, an Andean home, dignity, and whilst a young family claims the lady's old home, and that's a great thing, because we're not building enough family homes, and those homes will be released into the marketplace. It's a win-win. I can't see a downside. The minister's got a problem with not enough family properties in his rental. He's selling them faster than he's selling off Andean properties, family homes, quicker than he's providing new ones as a result of the Bridging Island plan. Deputy War's come up with a real cracker of an idea to increase the supply and incentivise downsizing. Brilliant. What's not to like about it? And there is absolute abilities to be supportive. Australia's done it, sir. 22,000 writees freed their homes in 2018. There's also been a scheme in England that's done it. It's worked. It benefits Jersey. Good idea. 200,000 to Lodestar, and we can actually slash pension poverty if we do it in this particular area. And I urge members to support the members' very sensible proposition.
So I know we've come to the time. You're about to say that, aren't you?
Oh, pardon?
I know we've come to the time, but I'm wondering if I could test the mood and suggest we stay on this evening.
Well, I was going to give members an indication of the facts. So far, I have 4 members indicating a desire to speak. Plus, of course, there will be the response from Deputy War. Deputy Mayor, is that your indication of a desire to speak as well?
Yes, it is.
And Deputy Feltham as well. Well, then I can assume there are at least 6 members to speak. It's a question from the Chief Minister as well. So, Deputy Tadier, you're testing the mood as to whether members wish to stay or to and finish the business today, or alternatively to come back tomorrow. Yeah.
So I would like to suggest that we stay this evening. I will speak, but I don't intend to speak for more than 4 or 5 minutes maximum. And if everyone who wants to speak does that, we could be finished in the best part of in a timely manner. So I could probably even manage 3.5 minutes.
Are you making the proposition that we stay until we've concluded business, Deputy? Is that proposition seconded?
Yes, sir.
Does any member wish to speak on that proposition?
So I've got there's a meeting at the Pomme d'Or tonight about the fort, which is a very critical meeting, and I'm expected to attend it, and it started 5 minutes ago, and it's really important that I attend that meeting.
Well, it's a matter for the Assembly, of course, Deputy, but you've made your point. Chair of BBC, did you want to... Sorry, I thought you had your light on. Deputy Moore.
Yes, sir. PPC actually have, I think, given guidance in the recent past that we should give notice if we're going to carry on into the evening. So I have also a meeting that started 5 minutes ago, and I'm sure other deputies and constables have other arrangements, because we all arrange our diaries according to the times that are set for our debates. This is a good debate, and I think it should carry on tomorrow.
Does any other member wish to speak on Deputy Reynolds?
Yes, I would just echo back to Deputy Tadier what he said at lunchtime, which was that we should adjourn because we shouldn't be encouraging members to hurry up their speeches in order to meet the deadline. I think we should have the debate tomorrow.
Deputy Ozef.
One word, sir. Maybe overnight the council ministers can all reconsider their comments and want to support it.
Constable Martin.
As speaking for myself, I actually have a meeting I have to attend, which is for the Liberations celebrations tonight, and also as chair of PPC, Deputy Moore is correct that we did give guidance, which I think was agreed by the whole Assembly, that we should have given due warning if we were going to stay late.
Very well. Well, the debate has been opened on it. It can't be withdrawn. It needs to be voted upon.
Can it not be withdrawn, sir?
Well, in theory, whilst it's proposed and seconded and the debate is open, it can only be withdrawn with the leave of the Assembly, of course, and it can be no circumstances. I suspect you might get the leave of the Assembly, Deputy, if you want to withdraw.
So I've listened to what people said, and I think the most persuasive point is that the mover can't be here, so I don't think we can expect to carry on, sir, and there's a number that wish to speak more than I thought, so let's withdraw, come back tomorrow.
Is the adjournment proposed?
Yes, sir.
Very well. The Assembly stands adjourned until 9:30 tomorrow morning.